Hearing in the bill of Great Asia Maritime Limited against Orion Shipping and Trade LLC.
Yes, Mr. Russell.
Lord Grateful. Lord, I appear on behalf of the appellant sellers, my friend Mr. McHenry, and my friends Mr. Lewis, KC, and Ms. Bond. I appear on behalf of the respondent buyers. We've agreed an equal division of time, 1/4 hours each. My plan is to go for about 2 hours this morning, leaving 15 minutes or so for rebuttal.
Are we to have contributions from juniors?
I understand that Ms. Bond will be dealing with the respondent's notice on their side. I'm afraid you're stuck with me for the duration. Lords, obviously, as you have seen, this case involves a contract for the sale of a ship on the 2012 Norwegian SALEFORM form. It was decided by the Court of Appeal, and it's now common ground, that sellers are under a readiness obligation. That's an obligation to exercise due diligence, to tender NOR, and be ready to deliver by the cancelling date. That readiness obligation, as we've called it, is an innominate term. It's not a condition of the contract. On the facts, the sellers were twice in breach of that readiness obligation. On the first occasion, the buyers agreed a new cancelling date. They lost the use of the vessel for a considerable period due to the late delivery, and they were awarded substantial compensation pursuant to Clause 14b for their loss of profits during that period of delay. Of course, that part of the award, awarding compensation for delay, is not challenged. Sellers were not ready by the second cancelling date either. By that time, the market had risen, so the vessel was worth more than the contract price. The buyers didn't, however, agree a new cancelling date. Instead, they exercised their Clause 14a right to cancel. Now, you may have seen that the facts were somewhat unusual in that the buyers did not, in the usual way, send a notice exercising their right to cancel. What they did, in fact, was arrest the vessel. But the tribunal held that the arrest of the vessel was a valid acceptance of the express contractual right, or an express exercise of the express contractual right to terminate. And nothing turns now on the fact that they exercised the right to terminate by an arrest rather than a simple notice exercising that right. As I say, it's somewhat unusual, perhaps, for buyers to terminate, notwithstanding that the market had risen. It was decided by the tribunal, and it's not challenged on appeal, that while sellers were in breach of the readiness obligation standard of due diligence, and thus were negligent in not being ready, they were not guilty of any repudiatory or renunciatory breach, and of course were not in breach of any condition of the contract. As in our written case, I'll tend to use repudiatory breach as a shorthand to include renunciatory breach and breach of condition in all submissions. On the facts, far from committing any renunciatory breach, sellers had made it clear that they intended to perform. And you can see that in paragraph 140 of the award, which is at page 176 of the key documents bundle. I'll give you the reference, but there's no need to turn it up. It's paragraph 140 at page 176. So the issue is whether, in those circumstances, buyers having cancelled the contract by exercising an express contractual right to cancel, but in the absence of any repudiatory breach, Clause 14b entitles buyers to recover compensation for loss of bargain. That's the issue which the court has to decide. I want to turn to the Memorandum of Agreement itself, which is in the core documents bundle at page 1253. But while we look at the MOA, I'd invite the court to look at it with two general principles in mind. I'll come back later to the authorities which we say clearly establish these two principles. The first I'll refer to as the causation principle, and the second I will refer to as the clear words principle. The essence of the causation principle is that if there is a repudiatory or renunciatory breach, that breach destroys the contractual bargain or goes to the root of the contractual bargain, putting it another way, and thus, as a matter of law, causes the loss of the contractual bargain. And that is inherent in the nature of a repudiatory breach. It's a breach that deprives the other party of substantially the whole benefit of the contract. It's obviously the Hong Kong Fair test.
But only if it's accepted.
Well, with respect, no. If it's accepted, then the contract comes to an end. But if it is not accepted, if the breach itself is sufficiently serious as to deprive the innocent party of substantially the whole benefit of the contract, then because that is the nature of the breach, of itself, it means that the original contractual bargain can no longer be fulfilled. If the innocent party does not accept the breach and some performance continues, the performance that continues is not the original bargain. The original bargain has been lost by definition because the breach has deprived the innocent party of substantially the whole benefit of the contract.
I'm not sure I follow that. I mean, if we've got a repudiatory breach, you either accept it or you don't accept it. If you don't accept it, the contract carries on and it can be fully performed thereafter.
Well, it will not be the original contractual bargain, however, because the performance that follows will be a performance which has substantially deprived the innocent party of substantially the whole benefit.
Doesn't that depend what the nature of the repudiatory breach is? I mean, if, for example, the settler blows up or scuttles the ship, I can quite easily understand your point that the contract is never going to go to completion in the way it was originally contemplated.
Yes.
But if he simply says, well, actually, I no longer have any intention of bringing the ship to the delivery place on the due date or at any date,
Yes.
that's a sort of renunciatory type of repudiatory breach, which is, if not accepted, a thing writ in water, so that the buyer, if he could ask for specific performance or exercise all his contractual remedies.
Well, but if there is a renunciatory breach, but pursuant to which the contract breaker is not going to perform,
He says he's not going to perform.
Yes.
He may be dragged to court kicking and screaming and made to perform.
Well, in the case of an order for specific performance, then yes, I accept there would be performance of the original bargain. But where you have a repudiatory breach, a past repudiatory breach, which by its nature deprives the innocent party of substantially the whole benefit of the contract, it follows that it is the breach itself that has destroyed the original bargain.
So, I mean, I have the words writ in water going through my mind, as I'm sure anyone does when talking about an unaccepted repudiatory breach. Is this an inroad into that principle, or is it just that that principle only applies to breaches which don't, for example, destroy the subject matter of the bargain?
Now, any repudiatory breach which is identified and classified as a repudiatory breach, using repudiatory breach in the strict sense, which is a breach which has already deprived the innocent party of substantially the whole benefit of the contract, is more than a thing written in water, because the fact of the breach itself has already, as I say, by definition, deprived the innocent party of substantially the whole benefit of the contract.
And the relevance of this point to this case is what?
Well, the relevance is that we say that where, in circumstances in which the innocent party is entitled to loss of bargain damages, is where the breach causes the loss of bargain. If the breach is not repudiatory or renunciatory, not a breach of condition, then the breach does not cause the loss of bargain. If the innocent party exercises an express contractual right to terminate, then it is, as a matter of law, the exercise of that right to terminate which causes the loss of the bargain.
Well, I can see that argument, except for the fact that you've got an express contractual right to compensation for their losses and all expenses.
Well, due compensation for their loss and all expenses.
Yes.
Yes.
So ordinarily you exercise an option, you get your deposit back, and you're no longer a party to the contract. But here you've got an express contractual right.
Yes, but the question is whether the express contractual right in 14b, due compensation for their loss and all expenses, is sufficient to create a right to recover
Then what
loss
does
of
it
bargain damages.
What does it do then?
Sorry?
What does it do then? What damages could you recover?
Well, if there is has been a repudiatory or renunciatory
No, if the buyer exercises the option to cancel the agreement,
yes,
what do losses cover then?
the loss will be any loss that has occurred during the period between the date on which the vessel should have been delivered and the cancelling date. And in addition...
So accrued losses?
Yes, and in addition, he recovers all expenses, which we say is sufficient to include wasted expenses, reliance losses in essence.
Okay.
But one has to remember that the provision applies...
And would that cover losses caused by providing for a crew to arrive at a certain time, which would only become a loss after you've exercised the option?
Well, it's not necessary for me to advance that argument as part of this case, which is focusing on loss of bargain damage.
Well,
I would say that it is sufficient to enable the buyer to recover those wasted costs because of the contrast in 14b between, if we look at 14b, it's at page 1261.
Sorry, page.
1261.
Thank you.
And so obviously it's clause 14a, which we referred to as 14a, which is lines 338 to 345, which creates the contractual right to terminate. If we look at 14 in two parts, 14a, the essence of 14a is creating the contractual right to terminate. We might call it an express termination provision, or express cancellation provision. And then lines 346 to 349 are the express compensation clause. And as it says, it applies whether or not buyers cancel this agreement. Now, if buyers don't cancel, then they will be entitled to recover damages for their loss caused by the delay in delivery. It's important to remember that the obligation, the readiness obligation, is an obligation to be ready to deliver on time. It's an obligation that goes to time of delivery, we say, rather than resulting in non-delivery or breach being akin to non-delivery. I'll take you to the relevant passages in the judgment in relation to that in a moment. So, in either case, whether there is cancellation or not, the innocent party can recover damages for their loss caused by the delay, which is the loss that is caused by the breach, and they recover their all expenses. But we say if the breach has been a repudiatory or renunciatory breach, then applying basic common law principles, they would also recover loss of bargain damages if they cancel. The question, as I say, that the court has to grapple with in this case is, is that express compensation clause in lines 346 to 349 sufficient to reverse what would be the common law position and create a right of recovery in respect of loss of bargain damages, in respect of a breach which is not repudiatory or renunciatory?
So as I understand, just going back to the point you're making about causation,
Yes.
you're resting your analysis on the fact that there is a difference between an express termination clause and termination at common law. And as I understand it, your argument is that if you pursue termination under the express contractual termination clause, you cannot recover loss of bargain because you say the loss is not, that loss is not caused by the breach, i.e. the repudiatory breach. It's caused by the exercise of the contractual termination right.
Yes. Sorry.
Yeah, and that presumably is the financings and Baldock type of analysis, is it?
Financing and Baldock, it's summed up very succinctly in the COS, in Lord Sumption's judgment in the COS. It's also set out clearly in the Australian authorities, AMEV, which is in the bundle and referred to in our skeleton. And we provided a copy yesterday of Cheval, which is to the same effect. But there are numerous cases, and it's accepted in the textbooks, that where there is no repudiatory breach, but the exercise of a contractual right to terminate, whether that contractual right to terminate arises because of a breach which is non-repudiatory or is not dependent on a breach at all, then as a matter of law, the cause of the loss of bargain is not the event which triggers the non-breach event which triggers the right to cancel. It is not the non-repudiatory breach which triggers the express right to cancel.
And then I think the point being put to you, effectively, Lord Hamlin first put it, is that in both situations, what is causing the loss might be said to be the exercise of the choice of the innocent party to terminate the contract.
Yes.
And that therefore the causation argument resting on, oh, well, that's because you have chosen to exercise that, looks potentially suspect, does it not?
Well, with respect, it doesn't look suspect because it is the innocent party's choice that causes the...
So it is in a repudiatory breach.
Well, in a sense...
That's the point I'm putting to you.
Yes, in a sense, yes. But the law views repudiatory and renunciatory breaches differently because the effect, the nature of the repudiatory or renunciatory breach is to go to the root of the contract. The law treats the exercise of the choice by the innocent party differently in the two circumstances.
Yes, thank you.
Just going back to the meaning of loss, in a situation where you do cancel, is it different to the situation where you don't, on your case? What loss covers? You said it covers delay in delivery.
Yes, it will be different if there has been a repudiatory breach and the buyer cancels. Because if the breach which triggers the payment of compensation pursuant to 14b is sufficiently serious to constitute a repudiatory breach or renunciatory breach, then the law treats that as being the cause of the loss of bargain.
Right, well, you get damages anyway there. So what is loss adding to it? Anything?
in that situation, not a lot is the answer. But this is where we perhaps come on to the clear words principle, which is that the parties contract against an established framework of rights and obligations. And it requires clear words to achieve a result which is materially different from that established framework of rights and obligations. And obviously, the more different the proposed outcome is, the clearer the words have to be to achieve that effect. And we say...
This is your Noverson presumption.
We've labelled it the Noverson presumption. It's really, we would say...
That's your label, is it?
It is.
Nobody else has labelled it that.
Correct. But I mean, we've applied that label because it's clearly stated in the judgment in the Noverson case. Really, it's simply either part and parcel of the Gilbert-Ash presumption or an analogous presumption to it.
But does it apply to any change to what otherwise would be your common law rights? Or?
Yes, we say it's a principle of general application, but clearly the more radical the departure from the established framework, then the clearer the words need to be to succeed in achieving that departure. What we do say is that it is a very radical departure indeed from the common law framework to hold that a party that exercises a contractual right to terminate is entitled to recover loss of bargain damages in circumstances where there has been no repudiatory conduct, no renunciatory conduct on the part of the, in this case, the seller. Perhaps the passage in which it's most clearly shown to be a principle of general application is in the judgment in Triple Point Tech, which is in the main hearing bundle at page 806. It's tab 30 if you're working from tabs or bookmark 30. And the context was that there was a clause in the contract which provided a cap on liability, but there was a carve-out for liability resulting from, amongst other things, negligence. And the question was whether negligence was to be given its ordinary meaning, which included failure to comply with a contractual duty to perform with reasonable care, or whether the carve-out was limited to cases of liability caused by a freestanding tort. But the analysis of the clear words principle appears in the judgment of Lord Leggett, with which my Lord Burrows agreed, at page 845 of the bundle.
This is under the heading Clear Words.
Clear words needed to restrict valuable rights.
Where do you want us to read to?
If you read from 106 to 108, please.
That appears to be rather different. It's about the taking away of rights and remedies in the common law.
My submission is broader than that, because if one looks at the very foot of 845, Lord Leggett says, it also remains necessary, however, to recognise that a vital part of the setting in which parties contract is a framework of rights and obligations established by the common law, often now codified in statute. These comprise duties imposed by the law of tort and also norms of commerce which have come to be recognised as ordinary incidents of particular types of contract or relationship, and which often take the form of terms implied in the contract by law.
But I mean, someone just reading those paragraphs might think that the best label to give this was a sort of anti-derogation principle. But the issue here is whether additional rights are being conferred by the use of the phrase compensation for loss.
But it's a derogation from the established framework of rights and obligations, because the established framework of rights and obligations is clear that one does not get loss of bargain damages, unless there is a repudiatory or renunciatory.
You get more,
yes,
not less.
Yes, but it is a derogation from that framework.
It's a funny kind of derogation when you get more rather than less.
Well, any advantage conferred on one party is a disbenefit conferred on the other. I mean,
So it is, but the phrase that, I mean, Clause 14 is all about conferring rights on the buyer.
yes.
It's not about derogating or not derogating from rights of the seller.
Well, I mean, one way of looking at it is that the common law position is that the seller can be in breach, but so long as he is not in repudiatory or renunciatory breach, he is not going to have to pay loss of bargain damages. And the creation of a right to claim loss of bargain damages in the buyer, the other side of that coin is it is a removal of a benefit that the seller has as a matter of common law, as part of the established framework.
It's a rather odd way to approach construing a contract, to take as your starting point that the parties wanted the common law, which is effectively what you're asking us to do.
Well,
the parties want the common law unless they make it very clear they don't.
well,
That's what you're saying.
well, in my submission, that is what Lord Leggett is saying. It is that you contract against an established framework, and there is a presumption that the established framework will apply, unless there is a clear derogation from that established framework. And
Can I just check, that's my own ignorance, is the Norwegian form only used where it's governed by English law?
Well, I mean, the answer to that is no, because the parties obviously could use the form to vary the choice of law clause.
But the choice of law is built into the form.
There's the standard form of the choice of law clause.
Okay, that's
is clause 16,
Yeah.
which is actually on the same page below the clause 14.
Yes, got it. Yeah, thank you. Well, that's for the MOA, but is this absolutely standard Norwegian form?
That part of it is yes.
Yeah, okay.
Yes, there is a choice. Well, sorry, Lerner is absolutely right. The standard form has two parts: it's A or B. Part A, clause A, is.
So what page are we on?
It's 1261.
Yeah.
So clause A is choice in favour of English law and LMA arbitration, and clause B, which has been deleted in this case, is for New York law and New York arbitration.
But the principle you're putting forward about not derogating, as it were, from common law rights is a principle of general application that would apply to every single contract there is.
Yes. I mean,
So,
but it's
every single contract has got to be drafted with particular care to make it absolutely clear that additional rights are being conferred.
Well, the greater the derogation, then the clearer the words have to be to achieve the result of derogation. And one mustn't get carried away and think this is some sort of impossibly high bar. I mean, clearly this contract itself derogates very substantially from the common law position because it creates a right to terminate where there is no breach at all.
But I mean, again, it's a very strange way of using derogation. It gives a right to terminate where the common law wouldn't give you a right to terminate.
Difference might be a better word than derogate.
Yes.
Well,
Or departure.
well,
The whole point about a contract is that the parties don't just want to rest on the common law relationship, which may be, if there's no contract at all, it would be a tort relationship.
yes.
They want to do something contractually which is different from what the ordinary law might otherwise provide. I mean, take the case of a professional retainer, where there's an underlying tortious obligation, but they want a contractual regime.
Yes.
And that's surely the same in any contractual situation. The contract is going to depart, in some respect, from where the parties would be if they were just left to their common law rights.
Well,
And if every benefit to one side is a derogation from the other side,
this benefit.
then as my lord said, you end up having to have the clear words principle applying to every line of every contract.
Well, in my submission, in a sense, it does, but most contracts and clauses are clear. The critical factor here is that there is an express compensation provision which is radically different from the position that would apply, if my friend is right, is radically different from the position that would pertain at common law. The position at common law is that absent a repudiatory or renunciatory breach, the non-repudiatory breach, where it is followed by an election to cancel, is not seen as, not treated as a matter of law as being the cause of the loss of bargain, and loss of bargain damages are not recoverable.
So contracting parties just couldn't rely upon reading the contract. They would have to actually understand what the differences between the contract and the common law were, and then they would have to understand whether the differences were substantial or insubstantial, and then they would have to work out whether clear words were used to change the common law position. A long way removed from just simply reading the contract.
Well, the parties to a contract are deemed to know the law. That's the knowledge of the law is baked into an interpretation or construction of contracts. And we say again, it is a fundamental principle of common law that a non-repudiatory breach, a non-renunciatory breach, does not sound in loss of bargain damages. And the law is, the case law is very clear that even where a contractual right to terminate is exercised, in the absence of a repudiatory or renunciatory breach, there is no recovery for loss of bargain damages. And so one has to ask oneself the question, in the light of Triple Point and the other cases that we've cited in relation to this principle, whether the words of the clause are sufficiently clear as to reverse what is a very clear common law position.
Is there any authority on clauses, contractual clauses, which either make or enable a party in certain circumstances to make time of the essence for the performance of a contractual obligation, where the general common law position is that time is not of the essence? Has the clear words principle ever been applied to clauses of that kind, so far as you know?
I'm not in a position to answer that question
okay.
from one way or another. I mean, one area where the clear words principle is applied, and this is, we say, important in this case, is in relation to the construction of clauses as conditions.
sort of before leaving the clear words proposition, it might give birth to an additional clause in standard contracts, and that is that if there are any differences between this contract and the common law, we have sought to and wish to apply clear words to exclude the common law position. And so the draftsman would attempt to get round the proposition you're putting forward. And contracts would become even more complicated.
Well, I mean, one could certainly insert a clause to that effect, or one could insert a clause to you know, I mean, in a sense, in some ways, if you have a clause that says you can't refer to headings as an aid to construction, which seems a bit odd. You could have a clause which says there should be no presumption that clear words are required to depart from the common law position. And that would then be a guide to both the reader and the court or tribunal in construing the contract. I mean, if there is a as we say there is a clear words principle, then self-evidently by sufficiently clear words, the parties could, I was going to say derogate again, but differ or depart from that common law position. As I say, if they do so expressly.
I think the difficulty I have with what you've been saying, although I sympathise with the argument, because I think you're basically saying the common law of contract applies, and that is the background against which all contracts are made.
Yes.
It's just invoking the clear words principle, because the clear words principle denotes a particularly high degree of clarity. And when we've got an exclusion of rights or a taking away of rights or remedies, you can understand that, because it's unlikely that a party would wish to have their rights taken away in this way. But I'm not sure you can flick over to say, well, it's the same degree of clarity that applies on the other side of the line, where you are conferring additional rights, because there's no reason, there's no unfairness or anything of that kind. It wouldn't seem so bizarre that people would agree to this. So that what you end up with, I think, is the proposition I'm going to put to you, is if there is a presumption at all, it's extremely weak. The degree of clarity is nothing like as strong as you would need if you were, for example, taking away somebody's rights. There may be a view that if you're departing, we want to see words that, okay, make clear that you're departing.
Yeah.
But I don't think it's the sort of high degree of clarity that a so-called clear words principle is really driving at. Am I wrong with that?
Yes. I say with the greatest respect, but yes, you are. Because you're looking at it only from the perspective of the party who is being gifted the right. The corollary of gifting the right to in this case, the buyer.
Is the word gifting an apt word?
Well, creating. Or,
both parties agree.
It creates a right. In addition to creating the right for the buyer, you are the same clause is imposing a very substantial obligation on the seller. It is imposing the obligation on the seller to pay substantial damages for loss of bargain in circumstances where, at common law, he would not be liable to pay damages for loss of bargain because he was not guilty of any repudiatory or renunciatory breach. And if the high standard of clarity is required to take away rights, we would say by exact analogy, the high standard of clarity is required to impose obligations on, in this case, the buyer.
But is that right? The essence of most contracts is that in various different places, one party is conferring rights on the other party. And the general principle of construction is to take a fairly fulsome view of what they have done by the words that they have used, not an excessive view, but certainly not a restrictive, oh, well, you only do anything, you only give anything to the other side if you do it by clear words. That would seem to me to run against some pretty deep-seated principles of interpretation.
Well, one can see in relation to, if you like, the primary obligations on each side. What we're looking at here, though, is, if you like, the sort of the secondary framework, the framework of rights and obligations that apply, for example, in the case of breach. And we say, as I said in response to Lord Burrows, the position at common law is that if you are not guilty of repudiatory or renunciatory breach, you are not liable to pay loss of bargain damages. A clause which purports to make you liable to do so, where you are not in repudiatory breach, where your conduct is not such as to deprive the other party of substantially the whole benefit of the contract, where your conduct does not go to the root of the contract, where your conduct is, as a matter of common law, not treated as being the cause of the loss of bargain. It is a radical departure from the common law, a substantial extra imposition and obligation to require you to pay loss of bargain damages. And in those circumstances, we say it is entirely consistent with a clear words principle, with the analysis of contracting against a framework of rights and obligations expressly discussed by Lord Leggett in his judgment in Triple Point, to say that clear words are required to achieve that departure.
Of course, ultimately, you're agreeing that it's the construction of the particular clause that we're going to have to turn to.
Yes.
I mean, you're putting us in the framework that we're going to have to find extremely clear words. Okay, but ultimately it's going to turn on that.
Yes.
Construction.
Yes. I mean, ultimately, you have to look at the clause in the particular contract, in the setting of the contract as a whole, and you have to decide whether, on a proper construction of that clause, it is sufficiently clear or not. We do not say that it is impossible to create a right to loss of bargain damages where there is no repudiatory breach.
I mean, it's quite significant, it might be said against you, that none of the books, as far as I can see, on interpretation, use the clear words principle to cover the sort of situation that you are asking it as to accept it covers. It certainly deals with taking away rights. So Lewison and McNeill, there's nothing in Chitty that links Noverson or anything of that kind. That seems a bit surprising if it's such a well-established principle.
Well, I fully accept that the books tend to look at it from the perspective of the taking away of rights. But in my submission, where you are imposing an obligation, disadvantaging a party by the imposition of an obligation, particularly an obligation which goes far beyond what the position would be at common law, that is no different from the removal of rights position. And I mean, Lewison, which is cited by my learned friend, says that a clear words.
Which paragraph?
Oh, I'm afraid I don't have the paragraph reference immediately to hand. He says that Lewison says that a clear words principle is underpinned by considerations of unjustness. But we say that that is directly applicable in our case, because it is, given that there is a very well-established common law principle that a non-repudiatory breach does not sound in loss of bargain damages, there is that where there is a contractual termination following a breach that is not repudiatory, the breach is not treated as being the cause of the loss of bargain. There is an injustice, a lack of justice, an unjustness in imposing an obligation to pay loss of bargain damages.
Even if on the proper construction of the contract, that's exactly what they agreed to do. They agreed to do. Is that unjust?
Well, but the point is that because as a starting point, it is unjust to require a party that has not caused the loss of bargain to have to pay loss of bargain damages. That's why you have to have clear words in the express compensation clause to create that obligation to pay loss of bargain damages absent a repudiatory breach. I mean, if one says, with the greatest respect, Lord, if one says that's what they've agreed to do, that's begging the question whether the clause is sufficiently clear to impose that obligation to pay loss of bargain damages or not.
We've probably already touched on this, and I'm sure you're going to come to it, but can I just be absolutely clear what you say the clause does cover? If it doesn't cover loss of bargain, you say it covers expenses and interest, and then you said, what were you saying, loss of profit for the...
Loss covers loss delay. The clause imposes an obligation to be ready to deliver on time. And if there is a breach of that obligation, such that delivery is late, then the seller has to compensate the buyer for any loss caused by the delay. And that may be very substantial. I mean, in this case, the buyers were awarded $1.65 million pursuant to Clause 14b in respect of the first period of proven negligence.
So what's the loss if there is a failure to provide the vessel on, say, the first of the month, and on the same day the buyer operates its right to cancel the contract? Okay. What's the loss there? On the same day. So on that occasion, what loss do you envisage?
Well, in that case, there will be no loss for delay because there has been no loss for delay.
Right.
The second part of the clause then provides that the buyer will be entitled to recover all expenses.
Right.
We say that all expenses is wide enough to encompass wasted expenses and reliance losses. But one could ask another question.
No, just make sure I fully understand. There would be no losses in such a circumstance.
There would be no loss for delay, yes. There would be no
and you can't envisage any other loss?
Well, the clause still allows recovery for the expenses.
Yeah, but I'm looking at the word loss.
Yes, exactly.
No other loss.
Correct.
No loss.
Correct.
Okay.
But by the same, I'm so sorry.
I mean, if there's cancellation and there's no delivery, so why are we looking at loss arising out of delayed delivery?
Because the breach of the clause, the breach of the readiness obligation, is not non-delivery. The breach of the obligation results in delay, results in the seller being late. What causes the non-delivery in the case of a non-repudiatory breach is simply the buyer's exercise of the right to cancel. And then that's really the essence of the case. Where it is the buyer's election to cancel that causes the loss of the bargain, why should sellers have to pay loss of bargain compensation.
It could be said against you that 14B expressly contemplates recovery for some loss, even if the buyers do cancel. Unless you interpret the last "and whether or not" part of the sentence as only applying to expenses. But it's not, I think, an easy reading of the clause.
Well, I was addressing Lord Stephen.
Well, I know, but I'm picking that up and saying,
yes,
I think you more or less conceded to my lord that if the buyer cancels by the expected delivery date, the notice date, notice of readiness date, he won't be able to recover any loss on your case from delay,
yes,
nor any other kind of loss that you can envisage. But it could be said that the words of clause 14b expressly contemplate that there may indeed be loss in that situation.
but that's so the position that was being put to me is the very narrow one of cancellation on the very same day.
Well, it's got to be quite soon after.
It may have to be quite soon.
How long have you got to cancel after if they're not ready if they don't serve notice of readiness for the road?
There's no express time limiting the right to cancel.
But there's always a risk that you will have affirmed if
Yes.
you don't cancel fairly.
There's a
So
risk.
a fairly swift cancellation.
Yes.
Therefore, a narrow period of existing life of the contract where you're going to cancel is a fairly typical way of looking and seeing how this works.
Yes, and in those circumstances, the quantum of the loss is likely to be small. By the same token, if the market has fallen, and the buyer cancels, then he suffers no market loss. What is the loss then? On that different factual scenario, answer: no loss. One can posit different factual situations in which there is substantial loss. One can posit different factual situations where there is... Well, one could posit situations where there is factual situations where there's loss and factual situations where there is no loss. The fact that there are some factual situations that one can posit.
But I think your case is that where there is a prompt cancellation, there can never actually be any loss, because all the delay lies in the future, and you can't think of any other kind of loss that would fit the bill. So it's nothing to do with whether the market's risen or fallen or whatever the other circumstances are. There just can't be any loss.
No, well, as a matter of principle, if there's a short period of delay, there can be compensation for that period of delay. But, I mean...
Okay.
So I'm having a little bit of difficulty getting my head around the short period of delay. Say, for instance, the one day delay. In the real world, what possible charter party could you possibly enter into for the or use of the vehicle of the vessel?
Well, one possible sanario would be if the buyer had already entered into a fixture for the vessel and was put in breach of that even by a short period of delay. It's possible to posit cases where delay causes substantial loss. But in my submission, it's not a particularly helpful approach to construing the contract to ask what is the quantum of the loss going to be in different circumstances. As I say, if one posits a falling market, then even on Malone Friends' case, there is no loss. So it's not a helpful guide to construction to say, in this factual situation, there wouldn't be any loss, would there?
But the difficulty, I think, that you face is that due compensation to the buyers for their loss. Let's just assume that means factual loss. There wouldn't be any factual loss if the market goes the other way. But there is a factual loss here.
Yes.
They have lost. factually. So how do you read, shall make due compensation to the buyers for their loss? What are you saying? Except where that loss is not recoverable at common law.
Well, it's loss which has been caused by the breach, not loss which has been caused by the buyer's exercise of their right to cancel. And we say this is the critical error in the Court of Appeal's judgment, because essentially Lord Justice Nucci adopted that line of reasoning that, as a matter of fact, they have suffered a loss, therefore that loss is recoverable. And
but if there is a matter of fact, if we're entering into a contract and we're thinking about, well, what are our losses going to be, you would expect the parties, just as a starting point, to think, well, we're entitled to recover our factual loss as a result of what you've done. That might be the starting point. You wouldn't expect to recover where you've not suffered factually the loss. So that's the starting point. And then you say, but you've got to put into that there's only this sort of legally recoverable loss, that they're actually, when they use that clause, they want to say, provided it's recoverable at common law. That's in effect what you're requiring us to read into the clause, isn't it?
no, because the misstep there is to say they're entitled to recover their factual loss because of what you've done. They haven't suffered the factual loss because of what the sellers have done.
You say that's factual causation, do you?
No, it's a principle of law that where there is no repudiatory breach, the non-repudiatory breach does not cause the loss.
Well, I think,
and it's counterintuitive in my submission to construe a clause which says compensation for their loss as compensation for a loss which has not been caused by the breach. I mean,
which has not been legally caused, although factually caused. I mean, it amounts to the same thing. You're saying not recoverable as a matter of law. Now, your justification for that is because the law has a rule on causation.
Yes.
But I was putting to you that if you're looking at it as a matter of fact, this clause covers what's happened here. So we have to somehow, on your submission, get to the view that it's not what's factually happened or was going to happen, but as a matter of law.
Well, as a matter of fact, in fact, the breach is irrelevant. As a matter of fact, it's the mere lateness itself which triggers the right to terminate. Buyers can, as a matter of fact, buyers can terminate whether or not there's any breach.
Yes, but the contract, I mean, doesn't go so far as saying you can recover loss of bargain in that.
It doesn't in those circumstances, yes.
It's qualified by saying yes, but you only get loss, any kind of loss,
if there's a breach.
if there is negligence.
Yes, that's
In
right.
other words, a failure of the best endeavours obligation to be ready in time.
Yes. But I mean,
You accept that factual causation would be satisfied here?
well, the factual causation is in the award, so I can't go behind that. The question, I mean, again, it comes down to the question is whether, as a matter of construction, this clause is sufficient to create a right to recover loss of bargain damages in circumstances where the law, as a matter of law, the breach does not cause, is not treated as causing the loss of bargain.
And why not? Why shouldn't that be the case? I mean, you're saying, well, it covers delay. So that, I mean, some people might call that incidentally. I mean, it seems to me there is a terminological problem here because some people might call that loss of bargain. If you receive something late, you're entitled to the bargain that you were entitled to. But let's leave that terminological quibble to one side. Why should people be agreeing to delay loss, but not what we're terming loss of bargain? Well, why should they agree to that?
Because of the principles of legal causation. The breach, which results in late delivery, is undoubtedly, as a matter of law, the cause of the delay losses. But as a matter of law, a non-repudiatory breach is not the cause of the loss of bargain. The cause of the loss of bargain is the buyer's election to terminate. And in our submission, it requires very clear words that are not here in this clause to create a right to compensation in respect of a loss which, as a matter of law, has not been caused by the breach. I mean, that is, it's a very radical, and we would say prima facie unjust result, that a party is held liable for a loss which, as a matter of law, it has not caused.
Can I just be absolutely clear that the proposition that this is not caused as a matter of law, you're going back to those authorities I think you gave me earlier. You're saying it's
Yes.
financings and
Costs.
yes, and costs
Yeah.
and so you say that that's not in dispute.
Yes. It shouldn't be, yes, yeah.
Right. I mean, the other side, of course, may say
Well, they have their
tenuous anyway.
they have their respondent's notice point, which
Yeah.
are perhaps convenient to deal with that very briefly now.
Okay.
They have their
Are you making anything of the words due compensation?
We do. I mean, we say that I think it's common ground that due compensation means appropriate or fair compensation, and that feeds into our argument that it is not due or fair or appropriate to award compensation for losses which are not caused by the breach as a matter of law. The word due doesn't appear in clause 13. And I don't wish to rely too heavily on that difference in wording between 13 and 14 because these contracts are not an exhibit of model drafting where one can assume that every word has been chosen with a very specific reason and purpose in mind. But notwithstanding that, due does appear in 14, and it, as I say, I think it's common ground that it means appropriate or fair in all the circumstances. And it is not due compensation to require payment of loss of bargain damages in circumstances where the breach has not caused the loss of bargain as a matter of law.
And why do you say that the Sale of Goods Act isn't a straightforward answer to the legal position? Why isn't this covered by non-delivery of a ship?
Because it's not a case of non-delivery. The breach doesn't cause, unless there is a repudiatory or renunciatory breach, the breach of the readiness obligation, the failure to be ready on time, isn't a case of non-delivery. The legal cause of the non-delivery is the exercise of the option.
It's back to the same point, really.
Yes. I mean, our case is a very simple one.
I mean, has the case been put this way at any stage before?
Yes, I mean the essence of it in the Court of Appeal is the same as reliance on the financing principle.
Yes, but in terms of legal causation.
I'm not sure if it was put in exactly the same way. I mean, I certainly remember some months ago reading the skeleton argument for the Court of Appeal and not considering that the way in which I intended to argue the case was a radical departure from the way in which it had been put in the skeleton argument. I mean, even if I put the argument somewhat differently from the way in which it was put below, and invite your lordship to deal with the argument as I put it.
Well, Mr. Russell, we've been barraging you with questions. And I can see the time ticking away. I don't want to prevent you from going into areas which you have yet to.
Yes. Well,
And I imagine, for example, you may want to say something slightly more detailed about some of the authorities. I don't know, although a lot of them are.
yes. I mean, I think if I look at my notes, I'm probably on page 1.
Well, that's what I slightly feared.
I suspect I'm going to have to do some trimming. What I was
I
going
may say that it's been very helpful for us that we've had this very free-ranging.
well, I mean,
That's what we're here for.
absolutely, and it's obviously much more helpful for me to know the sort of troubling the court rather than just reading through my notes in icy silence. So I'm equally very grateful for the opportunity to deal directly with the court's concerns. What I was going to do, probably about half an hour ago in response to Lord Stephen's comment or question, was look at one specific aspect of what we call the clear words principle. Because one might say that there is a wide principle, which is the one that we've been exploring so far in relation particularly to the passage in Triple Point. But specifically in relation to conditions, there is what one might call a narrower clear words position. Just bear with me a moment. And so there are a couple of stages to this submission. It is well established, we say, that a contract has to make it clear that a term is to be construed as a condition rather than an innominate term. There is if you like,
Yes, you did mention that first time round, although you ran past it quite quickly.
I would say I was diverted from it rather than running past it. But I want to come back to that and show you the authority in relation to that. And we say that's important in this case because, I mean, certainly there are two effects that classification of a term as a condition has. First is that any breach gives the innocent party the right to terminate. And second, any breach of a condition gives the innocent party the right to claim loss of bargain damages if they do terminate. As I say, I'll show you the Spark Appellant, which makes it clear in the Court of Appeal that the contract needs to make it clear and to be clear words to construe a term as a condition rather than an innominate term. Now, this clause, 14A, has the effect, it actually goes beyond making the readiness obligation a condition, in that it provides an express right to terminate when there is lateness, whether or not there is a breach of the readiness obligation. And 14A does that in clear terms. The effect of 14B, if my learned friend is right, is that it in effect turns for, the readiness obligation into a condition in relation to loss of bargain damages as well. Because on my learned friend's case, any breach of the readiness obligation will sound in loss of bargain damages. However serious, however trivial, whatever the consequences, whether the consequences are serious or trivial. And just as clear words are required to construe a clause as a condition, so we would say on this narrow version of the clear words principle, clear words are required to have the effect of turning a clause into a condition for the purposes of recovery of loss of bargain damages.
I mean, is there any case where that distinction's been made? Generally speaking, a clause which either does or doesn't impose a condition may have to have a certain clarity as to that it does, without going on and saying, and by the way, if you're in breach of it, I can recover loss and bargain damages. I mean, that just follows as a matter of law without having to spell it out, doesn't it?
Oh, absolutely. But sorry.
I think you're saying there are two elements to the clarity required. One is the clarity that has the conditional effect as enabling termination to take place for any breach.
Yes.
And it must clearly prescribe loss of bargain damages.
No, I'm sorry. No,
I may have misunderstood.
I haven't made myself clear.
I'm sorry.
The position at law is that for a contract to be construed as for a clause to be construed as a condition and not an innominate term, clear words are required.
Yeah.
If the contract clearly makes the term a condition and not an innominate term, then the inevitable consequence is that loss of bargain damages flow from any breach. It's not necessary. I don't suggest that in the context of a clause which is construed as a condition, there is some further hurdle that requires wording making it clear that loss of bargain damages will be payable, because it is inherent in the nature of a condition that the parties are taken to have agreed that loss of bargain damages will be payable in the result of any breach of the condition. That is in the nature of the condition itself. What I say is that where a clause is not a condition and is just an innominate term, which for the readiness obligation is, then if it is to be treated analogously to a condition, in that any breach is said to sound in loss of bargain damages, there have to be clear words to that effect.
Is there any authority to that effect? No.
Well,
being treated as analogous to a condition in one respect, not in every respect.
we haven't found any authority that is directly on point, but we say it must be the same principle or a principle very closely analogous to the principle that clear words are required to make a clause a condition.
Well,
so
I think Lord Justice Newdy identified the provision in a contract for the sale of land enabling a purchaser to make time of the essence if his vendor was delaying, such that any further delay automatically enabled the purchaser to walk away from the contract, get his deposit back, and I assume claim for loss of bargain, without that having to be spelt out. Now that sort of clause isn't, I think, within what everybody seems to regard as a condition in this case, because it's not there from the beginning and it's not automatic.
No, exactly. I mean, that's a separate line of authority.
It's quite like this, because here the buyer can in fact even retrospectively say, well, you didn't serve your notice by the relevant date, and even though that was only because of a breach of a best endeavours obligation, I can terminate, even if you're 12 hours late.
Yes, exactly. When here, the right to terminate is created whether or not there's a breach. I mean, that part goes beyond that.
It's an option to turn something into a condition. Even if everybody seems to agree it's not quite a condition. Yeah, I may be misrepresenting your opponent's position. You may say it is a condition, but I think it seems to be common ground that it's not a condition as such.
It is common ground that it's
Yes,
not a
I thought
condition.
so.
It's an anominate term.
Yes.
This case is different. I mean, I must say that line of authority on making time of the essence when it isn't otherwise of the essence, I've always find a rather curious proposition. But this is not that case in any event.
No, not quite.
Well, in my submission, not really at all, because what it does, it's in two parts, and the two parts are quite distinct. So the first part creates the express right to terminate in the event of any lateness, and that's there from the start. Yeah. It's baked into the contract. And the second part is the creation of a right to compensation where there is a breach of the innominate term. And the point that I'm making here is that just as clear words are required for the construction of an innominate term as a condition, so clear words should be required to achieve the result that any breach of the innominate term sounds in loss of bargain damages. I'm going to say it again, even where, as a matter of law, the breach hasn't caused the loss of the bargain, it is the exercise of the 14A option that has caused the loss of the bargain. I mean, just in relation to the point that clear words are required before a contract will be construed as a condition.
This is really just an amplification of your clear words principle, though, isn't it? If you write on your clear words principle, you don't really need another analogy, which might or might not be problematic, because you're having to split up the consequences of conditions. I mean, you've either got enough already, haven't you, without this additional point?
Well, it depends how you look at it. If I'm right on the broader principle, then yes, I've got enough already.
This is an alternative string to your bow.
This is
an alternative way of getting to the clear words principle.
It's a narrower clear words principle because even if you're against me on the broader clear words principle, in the context of a clause which has the effect of turning an innominate term into a condition, because the result of the clause is to create a right to loss of bargain compensation for any breach, whether repudiatory or not, then clear words are required to do that. So the decision in the Court of Appeal in Spark Appellant is at page 748. It's tab 27, bookmark 27. And in the judgment of Lord Justice Gross at paragraph 52.3, that's page 759. At 52.2, Lord Justice Gross says, secondly, Lord Scarman said that on a true construction of the contract, the parties have not made a particular term a condition, and if the breach of that term may result in trivial, minor, or very grave consequences, then the term is innominate. So thirdly, Lord Wilberforce, Lord Scarman, and Lord Roskill, unless the contract made it clear that a particular stipulation was a condition or only a warranty, it was to be treated as innominate, an innominate term. The courts should not be too ready to interpret contractual clauses as conditions. And one might ask, well, why not? And the answer is because they obviously have draconian consequences. And the same can be said of the construction proposed by learned friend adopted by the Court of Appeal in this case, that construing 14b as giving rise to a right to loss of bargain damages, even where there is no repudiatory breach, is a draconian consequence because, again, as I have said and continue to say, it creates a right in respect to compensation in respect of a loss of bargain that is not caused by the breach. And there are passages to the same effect in the judgment of Lord Hamblin at page 767 of the bundle. Paragraph 92. The modern English approach to the classification of contractual terms is that a term is innominate unless it is clear that it is intended to be a condition or a warranty. And in the judgment of the Master of the Rolls at 768, paragraph 99, is essentially a reference back to the paragraphs that I've already shown you.
Yes, it's quite difficult to apply Master Rolls' analysis to a contract which, in fact, enables the buyer to terminate without there being a breach at all. So you can't get much more draconian than that.
Correct. But that right is clearly established by 14A.
Yeah, absolutely. It's a tough world in which the seller is living under this contract on any view. I mean, bearing in mind the exigencies of life, which sometimes means your ship's not ready on time.
Yes, well, I mean, this is the... I mean, if one thinks of it in terms of allocation of risk, which is perhaps maybe a helpful way of looking at it, there are all sorts of reasons why a ship might be late, why a ship may not be ready for delivery by the cancellation date. Some may be the fault of the seller, and some may not be the fault of the seller. And what this clause does, so that the first layer of allocation of risk is allocates risk of lateness to the seller, in the sense that any lateness gives the buyer a right to cancel. There is then a narrower allocation of the risk of consequences of lateness in 14b, in which we say provides that if there is a breach, but a non-repudiatory breach, then there is a liability for loss and expenses, wasted expenses, but not for the loss of bargain, unless the breach is repudiatory or renunciatory, such that as a matter of law, it is viewed as and treated as causing the loss of bargain. And that is a sensibly calibrated allocation of risk, a tiered allocation of risk, if you will.
It seems to me that when one's talking about the clarity needed in order to have a condition rather than an innominate term, none of the judges are thinking about the secondary consequence. They're actually thinking, surely, about can you terminate for just breach of that term or not? That, I think, is the clarity that they're saying there needs to be. And the idea that they would be thinking, oh, well, that links in then to whether you can get loss of bargain damages strikes me as a bit far-fetched on the face of it.
Well, in the context of a long-time time charter, which is the context of the Star Capella, if the the right to terminate is treated as being a condition, the loss of bargain can be huge. So the secondary consequence, the right to recover loss of bargain damages in the context of a long-term time charter party is of very great significance. Really, I mean it's the whole. I mean, it's the essence of the decision in the Spark Appellant, which is that. So, bear in mind that the Spark Appellant there is a contractual right of withdrawal, whether or not it's treated as a condition. So it really, I think that in the Spark Appellant, it is the secondary obligation, it is the critical question, whether on exercise of the right to withdraw for non-payment of hire, the right to recover loss of bargain damages arises or not.
If you look, for example, at the Master of the Rolls, paragraphs 98 and 99, page 768,
Yes.
he makes it absolutely clear that what he's whether the time payment stipulation was such or a warranty sounding only in damages, as opposed to being able to terminate, that's what the question is about. That's why you need the clarity. Inherently unlikely, he says in paragraph 99, that contractor would wish to confer on them a right to treat the contract as an end for breach of a term, maybe broken in different ways. They're not thinking about the quantum of damages.
Well, as I say, where there's no doubt that there's a right to terminate under the withdrawal clause, I mean, the point of the issue in Stark Appellant, whether it's a condition or not, is does the exercise of the right sound in loss of bargain damages or not? And that's what the issue in the case really is.
The issue was basically defined at page 750, paragraph 1. And we don't have the what rights are available under the when the ship is withdrawn from service.
Well, if one looks at paragraph 1, is charterer's failure to pay an instalment a breach of a condition strictly so called,
Yeah.
or without more does such a failure merely entitle ship owners to withdraw? So in either event, they're entitled to withdraw. Yeah. The point is that if it is...
Well, insofar as I understand the answer to the first question, no, it's not.
Yes.
The answer to the second question, as yet I haven't read through this, so I don't know what the answer to the second question was.
Well, it's the same question. The two parts of the same question. The answer is it's not a condition. It merely entitles the ship owners to withdraw.
But does the withdrawal right give a right to due compensation of expenses? Well, there we are. It's different.
Yes, I mean it is right that the case does not. It's not on all fours by any stretch of the imagination, because it has an express termination clause, the withdrawal clause, but does not have, in addition, the express compensation clause in 14b. But it is, in my submission, not irrelevant, because the same factors apply in both cases. If you construe the withdrawal clause as a condition, the consequence is a right to recover loss of bargain damages. Here, we have an express compensation clause. The question is, as a matter of construction of that clause, does it sound in loss of bargain damages, even where there's been no repudiatory breach, and therefore the cause of the loss of bargain is not the breach. The cause of the loss of bargain is the election to terminate. Right. Well, Lords, we've given you the references in our skeleton argument to the relevant passages in the authorities that deal with both principles on which we rely. What I'd like to do, given the limited amount of time that I have, is first to address a number of points in relation to both the contract as a whole, and particularly the what is said to be a balance between clauses 13 and 14, and also touch on some of the supposed commercial considerations. And my learned friend says that if we go back to the contract, which is at, as I say, starts at 1253 in the bundle. And we have clause 13 at page 1260. And clause 14, obviously, at 1261. My learned friend submits that his construction creates a balance between clauses 13 and 14, and that in some way supports his construction. This is an argument that also found favour in the Court of Appeal. But actually, if one looks at, well, superficially, they look rather similar, being headed buyer's default and seller's default. In fact, they are really very different clauses indeed. Looking at clause 13, the first part of 13 deals with payment of the deposit. And of course, what is important to remember is that in relation to the payment of the deposit, the underlying obligation is a condition, so that any breach is repudiatory. And then, if one looks at the second part of the clause, this provides that if the sellers, the sellers have a right to cancel if the purchase price isn't paid on time. And in those circumstances, the sellers have the right to the release of the deposit. So the primary remedy that is given to the sellers under the second part, well, let's start again. Under the first part, they have a right to claim the deposit. That's the decision in the Griffin. And under the second part, they have a right to retain the deposit, even if that is greater than their actual losses. You'll note also that clause 13 is only addressing the situation where sellers do cancel. There's no equivalent wording that we see in 14b in relation to the clause applying whether or not the buyers cancel.
Just to be clear, do you accept that in both limbs of 13, loss of bargain is included within losses?
It is in relation to the first limb because the obligation to pay the deposit is a condition. In relation to the second limb, the obligation to make payment, in relation to that, prima facie pursuant to 10.1 of the Sale of Goods Act, the obligation to pay is not a condition, it's an innominate term. And consistently with my argument on 14b, we would say that the obligation to pay further compensation for their losses only arises if the failure to pay the purchase price is repudiatory or renunciatory. But obviously what clause 13, the second part of 13 does is, as I say, give rise to a right to retain the deposit regardless of losses incurred. So the regimes, the two regimes, in that sense, the clause 13b in particular is something of a departure from the compensatory principle, but is achieved by very clear words.
But the language of the identification of loss is pretty well identical in both limbs.
Yes, but I agree with that, and that's why I say if the failure to pay the purchase price is treated as being a breach of an innominate term, you don't get compensation for losses if they are higher than the deposit, unless the breach is repudiatory. But what 13b does is create, using clear words, create, if you like, a freestanding right to retain the deposit.
Well, not just to retain the deposit, but to get compensation on top. If the deposit is insufficient to cover
Yes.
the loss.
Yes.
It's difficult. I mean, it's difficult to think of anything other than loss of bargain that would overtop the deposit.
Well, indeed, but we say it only if the breach is repudiatory. Because, again, one comes back to construing compensation for their losses as being loss caused by the breach. One needs very clear words, we say, to create a situation where there is compensation to be paid for losses that are not caused by the breach. So
would you accept that if 13b did cover loss of bargain in a non-repudiatory breach situation, that would be an absolute knockout of your argument on 14? Or would you then say, oh, well, they're just different? I mean, are you saying anything turns on the particular wording of compensation for their losses, which is obviously for all expenses incurred together with interest? Are you saying that's essentially the same as 14 and they stand or fall together?
yes, I accept that because I mean, there's a difference in wording. Because 13b is further compensation for their losses, whereas 14b is due compensation for their loss. Now, one can't read anything into the difference in my submission between losses and loss. It's simply an example of somewhat careless drafting. One could, in theory, seek to construct an argument that due compensation is different from further compensation. But I would accept that it would be asking the word due to do too much heavy lifting to support an argument that there is a material difference between the two. The right answer is that if the obligation to pay the purchase price is viewed as an innominate term, in both cases, loss of bargain damages are only available if the breach is repudiatory. Where the position would be different is if the obligation to pay the purchase price is construed as a condition. Because in that case, clearly, loss of bargain damages would flow from any breach.
So you're saying that they're consistent?
Yes. Now, I want to make one submission in relation to the commercial consequences of the rival constructions. And that is to consider the position that a buyer is in if faced with lateness. And we say, if one looks at it from the position of the buyer faced with lateness, there is a very significant commercial benefit in our construction. So assume that the sellers are late, they're not ready by the cancelling date. As we've seen, there's no doubt that that gives buyers an unfettered right to cancel C14A, not dependent on whether sellers are in breach or not. Assume that the market has risen, as it had in this case. Before exercising their right to cancel, buyers are likely to want to know whether or not they'll recover the market loss for loss of bargain if they do cancel. Clearly, there will be maybe a greater incentive to cancel if they know that they are likely to get loss of bargain damages than if they don't. On the buyer's case, they will only get loss of bargain compensation if the lateness is due to sellers' proven negligence. So the question that the buyers ask themselves in determining whether they are likely to get loss of bargain compensation on the buyer's case is, were the sellers negligent? Have the sellers failed to exercise due diligence to be ready? On our case, the question that the sellers have, so that the buyers have to ask themselves to determine whether they get loss of bargain damages or not, is, were the sellers in repudiatory or renunciatory breach or not? Now, it's likely that in many cases, indeed most cases, it's going to be very difficult, if not impossible, for buyers to know if the lateness was due to the seller's negligence, seller's want of due diligence or not. It's going to depend, obviously, on the facts, highly fact-specific, and highly likely that prior to disclosure and witness statements, most of the relevant information is known only to buyers. And realistically, in many or most cases, buyers on their own case are not going to be able to assess at the time of exercising their option whether they are going to be able to recover loss of bargain damages or not, because it will be impossible for them to make a reasonably informed decision as to whether they will be able to establish negligence or not. By contrast, in our case, although the right to recover arises in narrower circumstances, it is much easier for sellers, I beg your pardon, it's much easier for buyers to assess whether prior to exercising their option, sellers are likely to be held to have been in repudiatory or renunciatory breach. Given that the breach is failure to be ready on time, and that gives rise to delay, as we have said in the skeleton argument, it's unlikely that delay itself is going to meet the threshold for repudiatory breach, substantially depriving the buyers of the benefit, or depriving the buyers of substantially the whole benefit of the contract. And all one has to do, really, is look at the period of delay. One can ask lawyers whether that period of delay is likely to be held long enough to constitute a repudiatory breach or not. And in relation to a renunciatory breach, which is the more likely route in our submission towards recovery of loss of bargain damages under 14b, the sellers have to have evinced an intention not to perform. But that is going to depend on their communications with the buyers, or their conduct of which buyers are aware. And so our argument is more commercial, as I say, in the sense that it enables buyers to make a much more informed assessment as to whether they're likely to get loss of bargain damages or not. And there's no uncommercial. There's a separate point. There's no uncommerciality in sellers getting the benefit from the increase in the market in circumstances where buyers have chosen to terminate. I mean, that is simply a feature of buyers having the option to terminate. In our case, the clause strikes a balance. It is a perfectly fair and sensible balance in commercial terms. If the buyers choose to exercise their option to terminate, notwithstanding the fact that the market has risen.
Doesn't deal with the limping contract where the market has risen, where the buyers want out, they're not prepared to hang around forever. But on your approach, they wouldn't be in a position to.
Well, if there is a continuing failure to deliver, if sellers say we're going to be ready next week and they're not ready, and your buyers give them another chance, sellers still not ready, buyers give them another chance, it obviously would depend on the facts. But in those circumstances, it would be unlikely that, in my submission, that a tribunal would hold that buyers had lost the right to terminate. They would still have the right to terminate, and they would be able to claim that the damages for the delay in the period during which the non-delivery took place, the failure to deliver took place. And one has to remember, I mean, it's one of the themes of Malher Feren's argument is that he in looking at commercial consequences, he repeatedly contrasts the position of what he labels the innocent buyer with what he labels the negligent seller. It's, in my submission, that is a false dichotomy, or at least not the relevant dichotomy. And the reason for that, again, goes back to the common law position that mere breach of contract doesn't create a right to terminate. the buyers only have a right to terminate in this case because the contract gives them that right to terminate under 14A, unless, of course, there is a repudiatory or renunciatory breach. Now,
Which is itself a big jump out of the common law framework.
it is. But it lies ill in the mouth of the buyers who have been granted that additional right to terminate, to effectively say, well, it's not fair if I don't exercise that right. I'm faced with a dilemma, because if I don't exercise that right, either I'm stuck with my negligent sellers if I want to take advantage of the rising market, or I don't want to be stuck with my negligent sellers, so I terminate, and I'm not entitled to loss of bargain damages unless I establish a repudiatory or renunciatory breach. I mean, essentially, what he's saying is, because I've been given this additional express contractual right to terminate, it should follow that I get loss of bargain damages as well. Otherwise, I'm put in this difficult position where I won't get my loss of bargain unless I stick with the negligent sellers. But I'd say that's seeking to rely on the creation of one right to create a separate and wholly different right, and is definitely analogous to turning it has the same effect as turning what it is agreed in common ground is an innominate term into a condition. Lord, as I say, we have set out the references in the written case to the passages in the cases like financings and the costs and so forth. We've also set out the cases that we rely on in relation to the clear words presumption. I'm pretty much at the end of my 2 hours, so rather than sort of taking it to half of a case, what I propose to do is save my time for reply and pick up on any points that my friend makes in reply.
Just to be clear, do you rely, and if so, how, on the reasoning of Mr. Justice Dias?
I mean, yes, we say her analysis is right, and in particular, the analysis that the nature of the breach is one that goes to delayed delivery, not non-delivery. The critical error that the Court of Appeal made, that Mrs. Justice Dias did not make, is to treat the seller's failure to be ready on time as a failure to deliver at all. In other words, to equate the failure to be ready on time with a case of non-delivery. That's really the critical point of distinction between the first instance judgment and the Court of Appeal judgment. And again, it comes back to the point established by financing and the other authorities. The reason why this is not a case of non-delivery is because the effective cause in law of the fact that the vessel is not delivered is not the breach, it's the exercise of the option. As I say, that is the fundamental flaw in the Court of Appeal's analysis. It's the fundamental flaw in my friend's analysis.
Well, thank you. This clock may be a minute fast, but I think you've got that.
Thank you.
Yes, Mr. Lewis.
Good afternoon. Subject to any questions, my structure will be sixfold. First, I will outline what this case is and is not about. Excuse me. Secondly, I will take my lords through the MOA, identifying in particular where buyer costs or expenses are liable to occur in the performance of the MOA. Thirdly, address the ordinary and natural meaning of clause 14b, which we say covers loss of bargain, and if necessary, clearly does so. Fourthly, deal with the consequences of the competing interpretations, which strongly favour our case. Fifthly, address seller's clear words presumption. And sixthly, time permitting, deal with authorities on the NSF form, which all support our case. So to outline first what this case is and is not about, we say it's a straightforward question of interpretation of an express compensation remedy and how it applies following contractual cancellation. Three things, all of which give rise to difficult issues, reflect what this case is not about. First, subject only to our respondent's notice point, which Ms. Bond will deal with, it is not about whether loss of bargain damages can ever be recovered following cancellation under a bare cancellation clause. By bare, I mean one that does not have an accompanying express compensation remedy, either because there is none or because any express provision is unenforceable as a penalty. That was the issue in Financings and Baldock, the Australian AMEV case, Langille and Kenerick, the Canadian case, and it's the issue on which Canadian law has diverged from English and Australian law, as Ms. Bond will detail further. That issue also drove the attempt to argue for a condition in the Spa Capella. It's also one focus of Professor Peel's termination paradox. But this case is different because of clause 14b, which is enforceable and means we are not dealing with a bare cancellation. If we only had 14a, all those authorities would be directly in point, but 14b sets the case apart. Secondly, this case is not about whether the claimant can recover more than the loss it has in fact suffered. That was the issue in Bungie and Nadera, Novison and Alimenta, and the Golden Victory. In this case, it is clear that the buyers did in fact suffer loss in the amount of the difference between the contract and market price. That is the indisputable finding of the tribunal. The different issue here is whether buyers cannot, as a matter of law, on the proper construction of 14b, recover that loss in fact suffered. Thirdly, this case is not about whether a party who terminated, citing ground A, can later rely on ground B, either to justify the termination or to claim damages, or both. That was the issue in Phones for You, in Dalkia Utilities and Celtec, Shell Egypt and Dana Gas, and Trademark Licensing and Leophilis. Here, the buyers were held by the tribunal to have cancelled under 14a and are claiming compensation under 14b. Distinct from those other cases, buyers are not here claiming compensation in reliance upon a basis other than the clause 14 cancellation that was upheld. So all of those...
Can you give me the third point again? I'm not entirely sure I understood it.
The third point is that there are a number of cases where a party who terminates does so on ground A, and then subsequently they say, we want to rely upon ground B. So, I mean, Boston Deep Sea Fishing, they do it defensively.
Okay.
But in other cases, they do it more than defensively. They do it either to justify the termination as a platform or to claim damages specifically based on that termination. And so that covers those other cases I mentioned.
And is that because the 14b expressly contemplates it applying where there has been a termination under 14a?
Exactly. So we follow through the course of 14a. We are not, for example, in a case like Shell Egypt and Dana Gas, where the reason given for termination was a contractual provision, clause 3.1.9, when they meant 3.1.8. But later they said, actually, we want you to find that we terminated for repudiatory breach and therefore can recover loss of bargain damages, which aren't there available under the contract. So all of those three different scenarios and the complex case law relating thereto, we say obscure that this is a straightforward case of interpretation of a standard form express compensation remedy. So on to my second subject. I want to take the laws through the MOA, identifying where buyer costs and expenses are liable to occur. And that will then inform our analysis of whether the remedies on seller's case are substantial in any way. The MOA is at page 1253, and we also have the standard form template at page 1177. The top right box on page 1253 shows how it is on SALEFORM 2012, which is the latest revision of a form on Cs originally adopted in 1956 and revised on the 5 occasions thereafter mentioned in that box. The first definition is banking days, which covers not only days on which banks are open in the country of currency of the price, but also in the price of closing. That's where the documents are to be exchanged for the payment as part of the documentary closing we'll see in a moment under clauses 3 and 8. There is also a definition for deposit holder, here identified as Hill Dickinson in Singapore, and that has costs implications, as we'll see in a moment. Clause 1 over the page, 1254, is the $15 million purchase price. Clause 2 covers the deposit. It's to be paid within 3 days of signing, and the deposit holder confirming that the account has been opened to receive the deposit. And then clause 2 at lines 40 and 41 provides for any fee, i.e. charged by the deposit holder for holding and releasing the deposit, to be borne equally by the parties. So that's a first category of expense incurred by buyers, namely their share of the cost of deposit arrangement. Clause 3 reflects the key reciprocal obligations and their timing. So we see on the standard wording after the first paragraph, on delivery of the vessel, but not later than 3 banking days after NOR under clause 5, the deposit is to be released and the balance of the price paid. Clause 4 deals with inspections, and as we saw with clause 16, here again the standard form offers 2 alternatives, A and B, to be deleted as applicable. One sees that suggestion at lines 73 to 74. Clause 4A, used here, applies where there's already been a documentary and physical inspection, whether by buyers themselves or a third-party inspection company such as IDWAL mentioned here. Clause 4B, which has been deleted but is more visible at page 1178, applies where there are to be prospective documentary and physical inspections after signing but before delivery. In either event, inspections are a clear second category of expense likely to be incurred by any buyer. Clause 5 on page 1255 deals with time and place of delivery and notices. And 5A at line 76 refers to the vessel being taken over. Whilst this does not explicitly refer to crew change, in practice it can mean that seller's crew disembarks and buyer's crew embarks at the point of physical delivery, handing over the keys to the ship, as it were. This aspect of the logistics was what led to the first phase of negligence in August 2021, whereby sellers failed to take reasonable care in arranging for disembarkation of their crew at Qingdao. And that's paragraph 26 of the Statement of Facts and Issues. Insofar as buyers have arranged an incoming crew that does not, in the event, board and take over the vessel at or around the cancelling date, that obviously has costs implications. So these crewing costs are a likely third category of expenses to be incurred by buyers. Clause 5A then at line 78 and 79 effectively provides a delivery window, or at least a window for NOR, which we know then triggers a 3-day period for completion. So we have a not before date for the NOR at line 78, and then the cancelling date here, 20th of August, but that effectively became 15th October 2021. 5B is narrowing notices in order that the buyer can be primed to take over the vessel. 5C caters for the extension of the cancelling date, as happened here. 5D provides that buyer's decision in relation to a proposed new cancelling date is without prejudice to any claim for damages buyers may have under clause 14. Just pausing there, seller's case on the impact of the word damages here may have changed. In their written case, paragraph 13, that's page 16 of the bundle,
So page what, sorry?
16 of the bundle, paragraph 13 of seller's written case, they juxtapose it with the reference to due compensation in clause 14b, although where that point goes is not clear. Below, sellers said it was shorthand for sums payable under clause 14, and one sees that, for example, at paragraph 46 of the Court of Appeal on page 86. We agree with the latter proposition and say that the phrases are interchangeable. Clause 6 covers divers inspections and dry docking, which can, if they occur, lead to further inspection-related costs and expenses. And then if we move on to page 1258, please. Clause 8 deals with documentary closing, which is the office-based part of the completion of the transaction, simultaneous with the physical taking over on board the vessel. So in exchange for payment, as we see at clause 8a, the sellers provide delivery documents as either listed in the standard form or here by specific wording they were to be all reasonable documentation to be listed in an addendum. Clause 8e, so now we're pleased on page 1260, shows how concurrently with that exchange in the documentary office-based closing, there is also a document handover of keys, certificates and other documents, plans, etc. on board the vessel. So from outgoing crew to incoming crew. So all of this engages a fourth distinct category of expense, namely the costs incurred, which are likely to include, if not exclusively be, legal costs in preparation for and at the documentary closing. Clauses 13 and 14 are the key clauses, and we will come back to them in a moment. For this run-through, the last clause to mention is clause 15, which entitles buyers to place representatives on board between payment of the deposit and delivery of the vessel for familiarisation. That's on page 1261. On our facts, buyers tried to invoke this clause but were prevented by sellers, which led to a minor claim for breach. One sees at paragraphs 180 to 183 of the award. For present purposes, the deployment of buyer familiarisation representatives is a distinct fifth type of expense that may be incurred by buyers in preparation for taking delivery of a ship. So we will come back to those 5 categories of expenses anon. My third section is to address the ordinary and natural meaning of clause 14b. We cover this at paragraphs 10 to 22 and especially 13 to 18 of our written case. It's pages 40 and following. As a preliminary observation, it may be common ground that the ordinary and natural meaning of clause 14b covers or can cover compensation for loss of bargain. We say that because the latest iteration of Seller's case comes close to an admission that the ordinary and natural meaning covers loss of bargain. Sellers say, where there has been a repudiatory breach, albeit one that was unaccepted because the only termination was a clause 14a cancellation, then clause 14b and its wording does cover loss of bargain. We say sellers are right to recognise that the ordinary and natural meaning of the words extends to loss of bargain, but are wrong to impose a prior repudiatory breach as a precondition of recovery of such loss of bargain under that wording. So our case on the text is at paragraph 14 of our written document, page 42. The ultimate question is the meaning of the widely drawn phrase due compensation to the buyers for their loss and for all expenses. We make 5 main textual points. First, the phrase due compensation in clause 14b is not confined to compensation that has already accrued. It means proper or appropriate compensation. That was the view correctly taken in both courts below. It's paragraph 71 to 72 in the Court of Appeal and 45 Roman 1 in the High Court. Due compensation is a somewhat old-fashioned phrase which has featured since the original NSF form in 1956, as one sees from a copy of that form at page 1152 of the bundle. But pausing here, we say that Seller's new hybrid case comes unstuck on the word due. So if one looks, for example, at paragraph 76 of their written case on page 28.
Is this still your first point?
Yes, thank you. It's addressing due compensation.
Which paragraph in the appellant's case?
76 on page 28, please. They say that where there is no repudiatory breach, due compensation cannot include loss of bargain because that would not be recoverable at common law. But lower down the same page at paragraph 80, they then say clause 14b does allow for loss of bargain where there is an unaccepted repudiatory breach, to which Seller's own objection could then be made, namely that loss of bargain would not be recoverable at common law where the repudiation has not been accepted. So we do say that the word due here becomes the focus or manifestation of Seller's inconsistent interpretation. Just as the wording sometimes covers loss of bargain and sometimes doesn't. So here the word due is sometimes given one meaning, sometimes another. They appear to rely upon it, here at least, as meaning due at common law as a key starting point to exclude loss of bargain absent repudiation. But they then ignore that when saying loss of bargain can be recoverable in a modest extension as a safety net where there is an unaccepted repudiation. So we say, rather than this Schrodinger's cat, as we put it in the written document, the better interpretation is that consistently given below, due just means proper or appropriate compensation.
I think your opponent says fair or appropriate. Is there anything in the distinction?
No.
No, it doesn't. He doesn't seem to maintain the sort of common law due analysis that you're shooting at the moment.
That may
Or at
be
least not orally.
That may be. My second textual point is to emphasise the unqualified reference to their loss. To echo what my Lord Burrows said, we say that would be understood by the reasonable person to mean the loss in fact suffered. Whereas here, loss of bargain is in fact suffered, it is within the natural meaning of their loss. That point on factual causation is well made in the Court of Appeal at paragraph 77. Factual causation is made good where clause 14b is relied upon following cancellation because buyers do not get the vessel for which they contracted by reason of seller's negligence. And that is why we say sellers are wrong to say the focus of the clause is late delivery. The clause contemplates two different outcomes. Where there is no cancellation, late delivery. Where there is cancellation, non-delivery. Sellers accept that if clause 14b said loss of bargain, then that would be recoverable. That's paragraph 85 over the page on page 29. But we say loss and all their expenses is wider than, and so encompasses loss of bargain. The third textual point is that the meaning of their loss, namely the loss in fact suffered, is supported by the prior word, compensation. The word compensation brings to mind the compensatory principle. Buyers are being compensated, which in the sale of goods context, where there is an available market for goods, as here, engages the normal market measure. The fourth textual point to emphasise is that the extension of the remedy to all expenses militates against the exclusion of loss of bargain. The clause would be in tension if buyers could recover all their expenses in fact suffered, but not the conventional type of market loss suffered where there is non-delivery following cancellation. The fact that wasted expenses may be recoverable under all expenses also leads to the need to give separate content to the word loss in the event of cancellation. That point was made in the Court of Appeal at paragraph 88. And we say, in the event of cancellation, that is best done by loss encompassing loss of bargain. And we'll come back, as I say, to where all the expenses fit in light of what we saw in the MOA. Meanwhile, the fifth and final textual point is to respond to my learned friend's reliance this morning on the whether or not buyers cancel wording. This was dealt with in the Court of Appeal at paragraph 73 on page 92 of the bundle. The purpose and meaning of that wording is to clarify that there is a remedy in either event. It is not, in its purpose or in its interpretation, apt to mean that the same loss is recoverable.
Well, there is compensation for loss in either event, but it may not be the same loss.
Exactly.
Yeah.
So those are the textual points, and I was then going to move on to the consequences of the competing interpretations, which is a more involved topic.
That might be better done at 2 o'clock.
Thank you.
Thank you. Court will adjourn. Yes.
Thank you. Good afternoon. I have 4 topics to cover on the consequences of the competing interpretations. 1, I will test the competing cases against their consequences using the likely types of loss and expense incurred by buyers, drawing on what we saw earlier in the MOA. 2, I will reinforce our headline point on risk allocation. 3, I will address the commercial consequences more generally of the 3 different interpretations offered so far by the sellers and Mrs. Justice Dias. 4, I will explain how our case makes the MOA more balanced as between buyer's default and seller's default. So topic 1, likely types of loss and expense. The key threshold for this test of the competing cases is the seller's case that the clause 14 cancellation by buyers is the legal and so the sole effective cause of the loss that flows from cancellation. And we say it has to be that legal cause, because if one asks what would have happened but for seller's negligent failure, the answer is that sellers would have been ready, the ship would have been delivered, and there would have been no loss of bargain. It is inherent, we say, in the nature of the contract that buyers expected to obtain the benefit of their bargain and not be deprived thereof by sellers' negligence.
Sorry, can I just take you back to the first point? Sorry, I didn't quite follow this. As I understood it, the buyer's argument, the seller's argument, your opponent's argument is that legal causation has to be understood in a particular way in this context because of well-established, I'll call it financing and Baldock line of authority. And therefore, there's a legal causation component that one has to take into account. Now, what is your answer to that? I don't think you can just say, well, factual causation does the job, it's but-for causation.
Well, the answer is twofold at this stage. We meet the legal causation argument head-on in paragraph 57 of our written case. That's page 61 and 62 of the bundle. And we do so including by relying on the Borealis case. We echo what was said in the Court of Appeal. A bright line rule that sellers' proven negligence is never the cause of buyer's loss of bargain, because buyer's termination is treated as a new intervening cause, is, we say, at odds with general principles on causation for breach of contract. My learned friend says, it's only if it's a prior repudiatory breach that we can recover for loss of bargain, and that's, to answer a question, not a case that was argued at any of the previous 3 hearings on this issue. And what we say is that when sellers try to defeat our claim for loss of bargain by saying, aha, there is no repudiatory breach here, they are advancing a position that is at odds with the general position on the causative consequences of breach of contract. Namely, that in order to operate as a break, as a new intervening cause, the claimant's conduct has to obliterate the prior wrongdoing. We say there is no question of that being the effect of an election to terminate in the face of negligent failure to be ready. But our second answer is to focus on the consequences of seller's legal causation argument, assuming a position of non-repudiatory breach. Because, of course...
Yeah, one second, just before we leave that, you would accept, would you, that loss in this clause must be limited by principles of contract law, such as remoteness, legal causation in the sense of novus actus interveniens, perhaps duty to mitigate. Would you accept that?
Yes, we accept one applies those principles.
Right. As I understand it, a way in which your opponent is putting his case is that this is an aspect of legal causation as the authorities have laid that down. That is, that the financings and Baldock approach makes a distinction between whether you are actually effecting termination through a termination clause or whether you're relying on a repudiatory breach. And the explanation put forward for that is that in relation to where you're exercising an express termination clause, the breach is not the cause. And the line of authority is effectively, therefore, it's not the legal cause.
We accept that that's a fair summary of their position. What we say is that that principle doesn't apply to the interpretation of an express provision. That principle applies when you have, and this was my first distinction before the shorter German, a bare cancellation provision. Yes, where we have a bare cancellation provision, then that principle applies, subject to the respondent's notice point saying it doesn't apply to one-off sale of goods contracts. But already by setting out that list of possible applicable principles, my Lord has created a conflict. Because my Lord said, we've got the principles of novus actus. Well, if we apply those principles, which is the point we make in paragraph 57, then the claimant's conduct in terminating here in response to a negligent failure to be ready is not a break in the chain of causation. It does not obliterate the prior wrongdoing. And so one is inevitably left to choose from a set of principles. And the question is whether, when one approaches the construction of an express compensation remedy, which is a bolt-on to a cancellation clause, so it's not a bare cancellation clause, one does so in a way that is hamstrung. I mean, all these points about financings and Bordeaux, etc., are really just a backdrop then to the clear words principle to which my learned friend then moves. He creates an inertia, a default position, as it were, and then uses that as a platform to say we need clear words to move us away from a default position. And we don't accept the premise, nor that clear words is required, because we don't accept that those principles apply where you have 14A and 14B. And what I want to do now is show why, on that case, effectively clause 14B becomes a hollow remedy, both in the event of no cancellation and the event of cancellation. And the starting point for that is we say one cannot have a different test of causation as between, on the one hand, their loss, and on the other hand, all expenses. The contrary does not seem to be suggested. So take first the case where buyers do not cancel and there's delayed delivery following seller's negligence. If we start with the 5 categories of expense itemised while looking at the MOA, first, the share of the deposit arrangement costs. That's not a loss if there is no cancellation. There may be some marginal extra expense for holding the deposit for longer if delivery is delayed. Secondly, there are the inspection costs. They're not a loss or a wasted expense at all unless the contract is called off. Thirdly, there's the crewing cost. It's unclear again here. There will be a loss if there's delayed delivery. There may be, again, a marginal extra cost if the crew need to be accommodated or paid for longer, pending taking over the vessel later than originally contracted. Fourth, we have the costs of the documentary closing, e.g. legal costs. If there is only ever one documentary closing, albeit postponed, there is no loss there. Fifthly, we have the cost of the buyer's representatives on board. Here again, if delivery is delayed, there will be at most a marginal extra cost if the representatives stay on board for longer and are then removed when the crew arrives. So all of those categories we looked at from the MOA are still necessary steps on the road to taking late delivery. Any increase in the relevant expense, for example, holding the deposit, is likely to be marginal insofar as there's a delay in delivery. And importantly, as identified in the Court of Appeal at paragraph 88, most of these expenses are not wasted at all unless the MOA is called off. To these heads of cost or expense, in a non-cancellation delayed delivery case, one can add the loss of use of the vessel or loss of profits, which its common ground may be recoverable in the event of delayed delivery. But we do say in the ordinary case where the delay is measured in days or at most weeks, that loss is likely to be relatively minor. So in summary, in the event of delayed delivery, where there's no cancellation, unless the delay is especially long because of peculiar circumstances, such as the 2 months here, where the sellers tried to squeeze in an extra voyage during August and September, see paragraphs 11 to 12 of the Statement of Facts and Issues, unless the delay is especially long, the due compensation remedy looks insubstantial in the event of no cancellation. That is perhaps unsurprising where the contract is performed, albeit somewhat later than intended. And that's all in a context where the buyers need to establish proven negligence to make any recovery at all for this hypothetical delayed delivery. So all that is relevant to whether the remedy then looks more or less substantial in the event of cancellation. So let's take the case where the buyers do cancel and there is non-delivery following seller's negligence. All the 5 categories of expense we itemise looking at the MOA will be wasted, although it's possible that the documentary closing costs may not arise at all if the MOA is cancelled before anyone attends a closing. But at least 1, the deposit arrangement fees, 2, the inspection costs, 3, the crewing costs, and 5, the buyer's representative costs will all have been wasted. Critically, they will only have been wasted because of the cancellation. So if we apply seller's argument in a non-repudiatory breach case that financings in Baldock dominates, then the sole effective legal cause of those wasted expenses will have been buyer's election to cancel. So on seller's case, if they are to be consistent on the application of legal causation as between loss and all expenses, none of those wasted expenses are recoverable. When we then come to look at what might be recoverable, sellers would only allow, again, a claim for loss of use between the cancelling date, or perhaps 3 banking days after the cancelling date, and the date of cancellation. But again, any such loss is likely to be measured in days, given the need for the buyers to cancel promptly or swiftly, as mentioned this morning and correctly recognised in the Court of Appeal at paragraph 89. So again, in summary, on the seller's case, in the event of cancellation and so non-delivery, unless there's also a repudiatory breach, the due compensation remedy looks insubstantial, yet again. Indeed, it starts to look even less substantial than the remedy in the event of no cancellation and delayed delivery, because all the wasted expenses are excluded as legally caused by the election to cancel, and any loss of use claim is likely to be short, if not shorter, than the loss of use claim in the event of delayed delivery. Again, the lack of substance to this remedy is all in a context where the buyers need to establish proven negligence to make any recovery. So one comes full circle to the submission accepted by the tribunal in the award at paragraph 163, namely that sellers have no satisfactory alternative explanation for what due compensation for their loss and all expenses means in the event of cancellation, if it does not cover loss of bargain. Sellers' answer to this, so in their written case at paragraph 118 on page 35, is to say it is not to be assumed that significant compensation is payable in every theoretical scenario. But on their case, it is hard to see how it is ever possible for significant compensation to be recoverable. On any view, the remedy is insubstantial where there is no cancellation. So it's not an answer to say it need not be of any significance where there is cancellation. We say the parties are taken to have intended there to be some benefit to establishing proven negligence where buyers have in fact lost their bargain. So much for the granular analysis of the different types of expense. Topic 2 of my submissions on consequences is the headline point we make at paragraph 23 of our written case, which we say is exemplified by the facts of this case. This is about risk allocation where buyers cancel in a rising or a risen market. We say buyers should be compensated for the loss of bargain in fact suffered, rather than sellers being left with a more valuable asset on their hands as the fruits of their negligence. So there are stages to this. We agree with sellers that much. We say that the parties have allocated the risk of market movement in the event of cancellation according to whether or not sellers are negligent in missing the cancelling date, etc. If sellers are not negligent, buyers bear the loss when buyers cancel. Absent negligence, buyers have no 14B claim. In the event, however, that the cancellation was a reaction to NOR or readiness failures caused by proven negligence, the dilemma is then as to whether the parties intended that loss of bargain to fall on the negligent sellers or still to be borne by the innocent buyers. And we do say it's uncommercial for negligent sellers to escape liability in that scenario. Put another way, the parties agreed that buyers are entitled to cancel at no loss to buyers if there has been proven negligence. Proven negligence is the fulcrum that's been used by the parties to determine the allocation of risk of buyers' loss of bargain. My learned friend says this morning, buyers already have a clear termination remedy for any delay. But it's a non sequitur then to say that the monetary remedy should be restricted so as to be insubstantial. Topic 3 on consequences. And this covers paragraphs 25 to 28 of our written case, page 48 and following. We test the 3 different alternative interpretations that we've faced through the history of this case. We say they're all uncommercial in not extending to loss of bargain in the event of cancellation for proven negligence, and that manifests in further related uncommercial consequences. So the first we address at paragraph 26 was the seller's case below that only accrued damages are covered. We say that gives clause 14b no purpose. They are already recoverable anyway for breach of the readiness obligation implied by clause 5. So that interpretation would make clause 14b completely hollow, both in the event of delayed delivery and in the event of cancellation. And we say that's improbable where the threshold is proving seller's negligence. My learned friend was asked if the same case was argued below. There were similarities. Mr. Wright relied on financings and Baldock, but the upshot of seller's case below was that loss of bargain damages are never recoverable. So even if there was an unaccepted repudiatory breach of contract. So the change is to the case here that they may be recoverable under 14b if there is a prior unaccepted repudiatory breach. That's new and didn't feature at any of the 3 stages below. The second alternative interpretation to our straightforward case was that of the judge. We covered that at paragraph 27. And in the judgment at paragraph 48 on page 131, she held that 14b covered accrued losses and expenses which have crystallised at the point of cancellation, but not prospective losses and expenses. And we say the problem with that was that it was internally inconsistent. It hasn't in full been defended in the Court of Appeal or here. It fails to explain why, either as a matter of wording or the principles of causation, the timing of incurring the particular loss or expense is what is critical. And one can test this by taking the costs of the crewing that we looked at already. On this hypothesis, in the event of cancellation following proven negligence, the costs of mobilising the crew to a delivery port would be recoverable, but not the costs of demobilising and repatriating the crew when delivery did not happen after cancellation. And we say it's not clear how such a limitation can be squared with the remedy for all expenses. Nor is it understood why demobilisation costs are losses that are caused by the election to terminate, whereas mobilisation crew costs are not also wasted and caused by the election to terminate. And these criticisms are also made in the Court of Appeal judgment at paragraph 88. For present purposes, we say it's uncommercial to have that arbitrary distinction upon what buyers can recover. Thirdly, seller's latest case, we address at paragraph 28, and we say again, clause 14b is hollow, albeit in the event of non-repudiatory breach. What this new case means is that without any basis in the wording, the parties have in effect put a double hurdle in front of cancelling buyers wishing to recover loss of bargain. They must not only prove seller's negligence, but also now prove seller's prior repudiatory breach. We say there is no good commercial justification as to why proving seller's negligence should not be enough for cancelling buyers to recover loss of bargain. What seller's written case says is that this is the solution to a dilemma arising from the Phones for You case. And we address that at paragraph 28.3 on page 50. So the dilemma arises where a party thinks it might be able to terminate a common law for repudiatory breach, but also has a clearer cut contractual termination provision. What should it do if the monetary remedies that follow are inconsistent? And we say there are 3 points on that dilemma. The first is that seller's case assumes what it seeks to prove, namely that loss of bargain is not generally recoverable under clause 14b, such that there are inconsistent consequences as between 14b recovery and common law recovery for repudiatory breach. Secondly, it applies 14b inconsistently as between similar situations of contractual cancellation for proven negligence based on a factor that does not feature in clause 14 at all, whether there was a prior unaccepted repudiation. And thirdly, whilst we accept that in cases where there are inconsistent consequences between contractual and common law termination, an innocent party may face a dilemma, there is a clear and more straightforward solution, namely sequential exercises of the different termination rights, very close in time, either in a single letter or alternatively in sequential letters sent moments apart, where the second termination is in the alternative to the first. To make good that simpler solution, we rely on the Shell Egypt case at tab 23, page 658, and the key passages at page 678, paragraph 34. Shell terminated a farming agreement for an Egyptian oil concession, mistakenly invoking clause 3.1.9. It was held that Shell had intended to and did terminate under clause 3.1.8. As the consequences of that contractual termination were different to the consequences of common law termination, Shell could not later say it had accepted a repudiatory breach of contract. So it's the third distinction I began with earlier. For present purposes, the key is the first sentence of paragraph 34. We say there is no reason why such sequential termination cannot be done, at least in any case where the contractual termination regime does not require a cure period. We also give, in paragraph 28.3.3 of our written case, reference to the Havila Kaistruten case. And for present purposes, that gives an example of this existing solution and of how it is well understood by practitioners and routinely deployed. If one turns, please, to page 447 of the bundle, one sees at paragraph 423, quoted by Mr. Justice Henshaw, the termination letter sent in this case by a shipyard. The shipyard purported to give 4 alternative bases for termination in a single letter, and each was given for example, looking at the last 4 lines on page 447, without prejudice to the foregoing basis or bases, and only if the SBC had not already been terminated as above. The shipyard did not make good any of its grounds of termination, but at paragraph 425 on page 448, Mr. Justice Henshaw correctly did not suggest there was any problem of principle with the sequential approach. So what sellers, at least in the written case, used as the justification for their new hybrid case, it is not a solution that is required because an existing and clear solution already exists. The fourth and final topic on consequences is the balance between clauses 13 and 14 of the MOA, the respective default clauses. There is some imbalance in that sellers do not have to prove negligence to recover loss of bargain damages if buyers fail to pay the deposit, or we say fail to pay the balance of the purchase price, and that is in contrast with 14b. But beyond that, we say sellers' interpretation would exacerbate the imbalance. So if we take up the MOA again, now at page 1260, under clause 13, the failures to pay the deposit and the purchase price have those accompanying rights to compensation for their losses and for all expenses incurred together with interest. It appears to be common ground that no difference of meaning is intended, as between the slight textual differences in 13 and 14 respectively. We say that such compensation extends to loss of bargain. That is common ground in respect of 13A, but it seems disputed in respect of 13B. So my learned friend says that loss of bargain is not recoverable under 13B for breach of the obligation to pay the purchase price where sellers cancel. We disagree. We're not aware of any English precedent on this. Most, if not all, of the clause 13 authorities are about failure to pay the deposit rather than to pay the purchase price after the deposit has been lodged. There may be some help in a Singaporean authority that is referred to in the Griffin. So if one goes, please, to...
Well, his argument, as I understood it, was they're consistent because it depends on whether there's a repudiatory breach.
And we say they're consistent because it doesn't. And that in both events, as suggested in the Griffin, albeit obiter, and as we say, follows as a matter of the ordinary and natural meaning of the language in 13 and 14b, that in either event, the non-defaulting party can recover loss of bargain where it cancels pursuant to its rights under 13b if it's a purchase price failure, and 14a if it's a delivery, etc. related failure. In the Griffin at page 434, paragraph 9, Lord Justice Tomlinson summarises the history, which he describes as controversial, in relation to whether the deposit can be recovered as a debt, and that was itself the subject of differences of view prior to that decision as between England and Singapore. So the Blankenstein is covered at Roman 2 and 3, and then at Roman 4, Lord Justice Tomlinson goes on to deal with the Anna Spiritu, where it was held that the deposit couldn't be recovered, but the remedy was for loss of bargain damages instead. Now, that may not answer conclusively the point about 13B in relation to purchase price, but it is another situation where loss of bargain was in the frame in relation to these default clauses. So we say we have clause 13 where for breach of absolute payment obligations, sellers may recover loss of bargain as contractual compensation. And the similarly worded clause 14 where, subject to establishing proven negligence, sellers may correspondingly recover loss of bargain. And we say it would be no answer to say that clause 13 deals with conditions whereas clause 14 doesn't, because the key phrase is materially the same. And that's what matters for the purposes of interpretation and balance in the contract. So then I come to my fifth section, which is seller's clear words presumption. And we've addressed this at paragraphs 44 to 51 of the written case, starting on page 55. We say there is no authority for this presumption, nor is it grounded in principle. As to authority, it's not established by any of the cases on which sellers rely. It's hard to compete with Lord Justice Nugie's dismissal of this argument at paragraphs 127 to 134, which we support, but I will try. First, sellers rely on Bungie and Madeira, and that is at page 240 of the bundle. In this case, FOB Russian milling wheat sellers were in premature repudiation, but that caused buyers no loss because the Russian export embargo on which they relied would have led to a subsequent lawful cancellation anyway. The key point is that in this case, the sellers made a similar but less ambitious submission to that of the sellers in this case, and it was rejected by this court. So if we pick it up, please, on page 247 at paragraph 24, Mr. Rainey for sellers submitted there was a strong presumption that an express clause was not intended to depart from the compensatory principle, and that unless the contract provided otherwise in clear terms, damages would not be awarded where no loss was sustained. At paragraph 26, in the middle of that paragraph, Lord Sumption accepted a more moderate version of Mr. Rainey's suggested presumption. So he said there can be no scope for a presumption that the parties intended the same measure as the compensatory principle would produce at common law. However, and this is the last sentence of paragraph 26, it could be assumed that in the absence of clear words, the clause would not be intended to operate arbitrarily, for example, by producing a result unrelated to anything which the parties can reasonably have expected to approximate to the true loss. That, we say, is the loss in fact suffered. So that presumption does not require clear words for loss of bargain to be recoverable when loss of bargain has in fact been suffered. There is nothing arbitrary in our interpretation of 14b. On page 249, paragraph 34, Lord Sumption revisits the same point by reference to Novison and Alimenta. He says here, and this is where there's an echo in what my learned friend says, that on the one hand there's the Gilbert-Ash principle, and the analysis would have been the same in the converse case, so there could be a converse presumption to Gilbert-Ash if it was suggested that a clause impliedly required the award of a head of damage which has not been suffered. And we say that means loss not in fact suffered. After referring to Novison in the balance of paragraph 34, paragraph 35, Lord Sumption endorses it as consistent with principle, because the alternative would have been an arbitrary means of recovering very substantial damages where there had been no loss at all. So Lord Sumption's more moderate presumption achieved what Sellers required in those cases of Bungay and would have done in Novison, where no loss had in fact been suffered. But it doesn't support the different presumption that clear words are required to confer a right to damages where none would arise at common law. Secondly, Sellers rely upon Novison. It's the name they gave to the presumption. That is at page 437. Sorry, that's a false reference. 473. And the key issue was materially identical to Bungay. FOB Senegal groundnut oil sellers had jumped the gun in terminating based upon a Senegalese export ban, but in the event the ban continued until sellers could have lawfully terminated anyway. Sellers were in repudiatory breach, which buyers accepted. The only issue was about substantial damages. And one sees that in paragraph 4, summarising the facts, on page 477, particularly sub-paragraph 3. And the question of law is at paragraph 7 on page 478. So buyers in fact suffered no loss. That is the key context in which the dicta of Mr. Justice Popwell at paragraph 17 on page 482 have to be understood. So at small e in the margin, when the judge says, if no remedy in the form of entitlement to damages is conferred by law, clear words will be required. He means no substantial remedy, because buyers have in fact suffered no loss. And that point is clearer still at small g in the margin, where he says, where with hindsight it can be seen that no loss has occurred, it would require, in my judgment, clear words if the parties wished to achieve the opposite result. So if we put Bungay to one side, as at 2013, Novison established at most a presumption that is relevant to the no loss situation. And no doubt it then grounded the submission that we saw Mr. Rainey make for sellers in 2015 in Bungay. But what Mr. Justice Popwell said in 2013 was anyway superseded by the more moderate presumption set out in paragraph 26 of Bungay by Lord Sumption. So back to our case. Clause 14b does clearly confer a remedy not otherwise available by law, i.e. that would not exist in the event of a bare cancellation. That's why, at all three stages below, financings and Baldock was correctly distinguished. The only question then is what that remedy means, i.e. how far it extends. The third authority invoked by sellers for their presumption is the Spa Capella, albeit at first instance, and not in the Court of Appeal where nothing was said about presumptions. As to paragraphs 97 and 98 of the Spa Capella, which are found at page 714, it is enough to rely upon what Lord Justice Nugee said in the judgment at paragraphs 132 to 133, and that's page 108 of the bundle. sellers also...
That's a very oblique submission,
Sorry. Yes.
requiring tired fingers to go dashing through to another part of the bundle. I mean, what's the point?
The point is that Mr. Justice Popplewell was dealing, similarly to the financing Baldock situation, with the question of whether, where one had a bare cancellation right, a withdrawal right, there could be superadded a right to loss of bargain. Mm-hmm. And in that context, it was the condition debate. But here, one is already a significant step further forward because one does have a monetary remedy. And therefore, what one is left to do is just to construe, as Lord Justice Diplock said in Financings in Baldock itself at page 121, when we're asking what the consequences are of a termination, if it's a bare cancellation clause, then they follow the rule that's been discussed. But if the contract provides for something more, then it's just a question of construction of what that something more is.
So you referred to the Court of Appeal dealing with this case at what paragraphs?
132 to 133.
And page?
107 to 108. And
you referred to financing in Baldwin at paragraph 121, which page number, please?
Sorry, I referred to financings in Baldock as a separate point, and we can see that point on page 342 of the bundle. And so in that case, because the additional provisions for monetary relief had been held unenforceable as a penalty, one was left in substance with a bare cancellation provision. But what Lord Justice Diplock said here, after dealing with the termination, third line, whether the contract does more than this and confers any other rights or remedies on either party on the termination of the contract depends upon the true construction of the relevant provision. And that's what we say, nothing more, nothing less. And that's what that's consistent with what Lord Justice Nugent is saying in paragraph 133. He is distinguishing the points made by Mr. Justice Popplewell and Spa Capella as going to the question of existence of any monetary remedy. That's not in any doubt. We have one, and we are just arguing about its extent. The fourth case on which the sellers rely since yesterday lunchtime is the Cheville case. And to understand the dicta in that, one has to see the lessor's arguments. So if my lords have that available somewhere in loose copy or otherwise.
Is this the one recently sent?
Yes. One of the ones my learned friend sent yesterday.
Yes, we have. Well, we've got it electronically. But I mean, if anybody else wants a paper one. Anybody else want a paper one? No. No, thank you.
It was similar to a financing and Baldock situation because a lessor had exercised the right of re-entry and was claiming loss of bargain damages. If we take it up at page 625, third paragraph, the primary submission that was being made was that the obligation to pay rent was an essential term of the contract, aka a condition, by reason of clause 9a of the contract there. And then the alternative submission was that there had been a renunciation by the lessee. And if one then moves on, please, to page 627, on which my own friends rely, Chief Justice Gibbs then says in the paragraph starting at the bottom, in my opinion, it does not follow from the fact that the contract gave the respondent the right to terminate that it conferred on it the further right to recover damages as compensation for the loss. And what Chief Justice Gibbs does is then
Sorry, which page are you on?
627.
Oh, I'm sorry, thank you.
Page 8.
And over onto 628, Chief Justice Gibbs goes through the different triggers under the termination clause there. Some were breaches, some were not. And he then gives examples of trivial failures. And that is the context in which he then says, in the middle of the page, it would require very clear words to bring about the result, which in some circumstances would be quite unjust, that whenever a lessor could exercise the right given by the clause to re-enter, he could also recover damages for loss of bargain. In context, what was being said was that clear words would be required to establish that the obligation to pay rent and indeed all other aspects of Clause 9A were effectively conditions of the contract. The same ambitious submission is seen at page, or referred to at the bottom of page 635.
So just before we leave that, where is the clause that's under consideration in this case?
Clause 9A starts on page 623.
Just give me a moment.
There's the clause, yes. It's the typical forfeiture clause.
Okay. And what was being said about it by the lessor is perhaps most succinctly summarised on page 635.
635.
635 at the bottom of the page. On the other hand, the board argues, the board is the lessor, that clause 9A should be construed as an express indication by the parties that every covenant, including the covenant to pay rent in the manner prescribed, is an essential term of the contract and carries the implication that any breach will not only entitle re-entry but also loss of bargain. So it's similar to the Rice and Great Yarmouth point about any breach being one that effectively amounts to a condition or any term, any covenant. And at page 637, that is then the context in which there is a second reference to a clear expression of intention on which sellers rely. Again, it's in the context of that argument that every covenant was an essential term, i.e. condition. So we don't accept that Cheval is any support for sellers' proposed presumption to be applied to express compensation provisions. Finally, we don't accept, in terms of authorities, that one can extrapolate from the general requirement for clarity before a term is classified as a condition with all that brings with it. One, there is no authority for that, and it runs against Lord Sumption's presumption in Bungie, applicable to express damages or compensation clauses. Two, it implies that there is some punitive element to the normal market measure compensating the innocent party. And that I'll come back to when we look at Lewison and the unfairness theme that runs through clear words requirements. And three, here, the parties have agreed a remedy of termination for any lateness, but then have imposed a separate hurdle of proven negligence before there can be monetary recovery. And so we don't accept that a clear words presumption, at least beyond that of Lord Sumption in Bungie, is apposite.
So are you saying that there's no principle that you need clear words to make clear a term as a condition?
No. No, I'm saying that clear words is not a relevant requirement in respect of clause 14b.
Right.
And its requirement to its extension to loss of bargain. What I'm saying is that my learned friend is trying to extrapolate, and it's an overreach to get from Spa Capella, dealing with that general question, to what he needs as a presumption applicable to this express compensation provision.
You say it's not analogous. The exercise is not analogous, really.
Yes, exactly so.
Are you going to deal with the triple point case, which he placed some reliance on?
Yes, so I'm coming on to that now. So I've been dealing with authorities generally, and then I was going to deal with clear words as a matter of principle, but perhaps contrarily cover triple points when dealing with principle. On clear words and principle, our key arguments are at paragraphs 47 and 50 of our written document, starting on page 56. So at paragraph 47, what we say is that the theme, or at least a leitmotif running through clear words canons of construction, is that their purpose is to avoid unfair results. So I make good that proposition by reference to Lewison on the interpretation of contracts, which is page 1014 of the bundle, please. And the author here groups together various strands of the or separate clear words principles on the basis that the commonality is they apply where the construction contended for would produce an unfair result. To answer my Lord Briggs' question, there is no mention in this passage going on to page 1016, which covers lots of different scenarios, of cases where a party makes time of the essence. In this bundle, the only treatment of making time of the essence is in the Samarenko case, especially paragraph 34 of Lord Justice Lewison at page 621. And there, digressing, the focus is on the historical distinction between common law and equity in their approach to contractual time limits. Equity would intervene to prevent an injured party from relying on a breach of condition until a notice of a reasonable length had expired. But back to Lewison on page 1014, the passage starts with the well-known dictum of Lord Hoffman in BCCI and Alley. And then if one turns on to page 1015 at 7.174, one of the principles or applications thereof now within this umbrella is the Bungy presumption we have just looked at in relation to an agreed damages clause. And so again, there is nothing unfair in clause 14b covering loss of bargain.
This section doesn't seem to discuss Gilbert Ash, does it?
No, well, yes, sorry. That is towards the top of page 1015, third line, exclude a right of set-off, and then 514 is WR Grimm.
515.
51.
Well, no, that's WRM group.
I mean, the right of set-off is the Gilbert Ash point, but the authority given is not that.
No, it's WRM group and Wood.
Yeah. And so the consequence here is not draconian, contrary to my learned friend's reliance on Spa Capella, and it is not inherently unlikely that the parties intended loss of bargain for cancellation upon negligence, to paraphrase the Master of the Rolls at paragraph 99 in the Spa Capella. Our second point of principle is at paragraph 50, and this comes on to Gilbert Ash and we'll address triple point. So we say there is a contrast between the Gilbert Ash principle and the current situation, and this was debated this morning with my learned friend. On the one hand, there is the issue of taking away rights that otherwise arise by operation of law, that's Gilbert Ash, or are created by the contract itself, that's MUR and RTI. And the same was seen in triple point, as you were shown this morning, at paragraphs 106 to 108. The point there in the title is about the taking away of rights. On the other hand, here, there is the question of granting rights and remedies. The parties agreeing to confer by the contract itself express compensation remedies pursuant to a contractual cancellation. In the former scenario, there are sound policy reasons for requiring clear words before a party is deprived of the rights that otherwise exist. A party may not realise that its rights, whether common law or contractual, are being taken away by less than clear wording, and that results in unfairness, the umbrella policy. There is also a danger of a party being misled if it considers it has rights, whether at common law or contractual, which are then foregone by less than clear wording, and one sees that word foregone also used throughout those authorities. But in our scenario, there is no equivalent policy reason for requiring clear words before the parties confer a particular remedy, a fortiori before they confer a particular remedy for negligent breach of contract. The interpretation of commercial contracts does not need a further rule of strict construction which creates a barrier to the draftspeople achieving a particular result. The conclusion of the contract, the MOA, is the source of the parties' rights. In this event, the right to cancel under 14A and to compensation under 14B. So like other remedies, or at least remedies that produce commercially reasonable and fair results, Clause 14 should be interpreted in accordance with ordinary principles of interpretation, giving effect to what the parties have agreed without any strict rule of construction. Finally, on clear words, if I'm wrong about all that, insofar as there is any relevant principle here, it is one that must necessarily apply as a question of degree. And that may be common ground based upon the debate this morning. So in relation to the Gilbert-Ash principle, the more valuable the right, the clearer the wording will have to be to remove it. So said Lord Justice Morbick in the Gearbolt case at paragraph 23, which is page 781 in the last line. Lord Leggett in Triple Point at paragraph 108 on page 846 also said the strength of the Gilbert-Ash principle will vary according to the circumstances of the case, and then at paragraph 110 went on to cite Lord Justice Morbick. Here we say that reinforces that at most the Bunge presumption should apply. The relevant benchmark from which one assesses the extent of departure is the compensatory principle. And since there is no departure therefrom, where buyers have in fact suffered loss of bargain, any additional requirement for clarity, if there is one, is muted on our facts.
But surely the common law rules about causation are designed to identify what is or isn't within the confines of the compensatory principle.
Yes.
So that if there is an established common law rule of causation that where you terminate after a non-repudiatory breach, it's the termination rather than the breach that causes your loss of bargain. I mean, that's just one of common law's many tools, isn't it, for making sure the compensatory principle is adhered to.
That is a tool that applies on its terms, see Lord Justice Diplock in Financings, to a bare cancellation. It is not a tool that then one continues to take out of the toolbox where one has a cancellation plus
A damages clause, yeah.
If I'm wrong about all that, clause 14b is clear or sufficiently clear.
Yeah.
Loss is wide enough to cover loss of bargain.
And what do you say about Lord Legate's paragraph 108 on page 8, 4, 5 and 6, which is, I think, particularly what your opponent was relying on this morning?
A triple point, yes.
We say it doesn't apply in the situation we are in of asking what is the extent of the right that has been contractually conferred. It is about deprivation. It is about derogation. The heading one has back on page 845 is to restrict valuable rights. And so Lord Legate deals with the duties that arise as ordinary incidents of particular types of contract or relationship. And what that entails is that the beneficiary of the duty has a legitimate expectation as a starting point that they are going to benefit from valuable rights by reason of those duties that are ordinary incidents. Then we ask, have those rights been taken away? And the problem is, if one looks at the extension of the Gilbert-Ash principle in the MUR RTI case to the removal of contractual rights, then we suddenly have two principles that butt right up against each other, because we have a principle that we, my learned friend says, can't confer rights, or at least remedies here, without clear words, and then we have another principle that we can't take them away without clear words. So how is the draftsperson left to put the words on the blank piece of paper without having some sort of boilerplate that they don't want it to be that complicated, they just want the ordinary principles to be applied?
Thank you. Would a way of shortening your approach to this construction approach be as follows? Clause 14A, if it had stood on its own, would not have conferred a right to loss of bargain damages on the buyer unless the conduct which had led to the cancellation had been repudiatory. And possibly, you would say, and the contract had been cancelled through the exercise of a right to repudiate rather than the exercise of clause 14. Now, leave that on one side. There may be two sides to that. Mm-hmm. But in this case, by inserting clause 14b, the parties have firstly provided, by way of bolt-on or addition to the right to cancel, a right to damages, and secondly, and all importantly, identified as the touchstone for the triggering of that right negligence rather than repudiatory conduct.
Yes, exactly so. And that's what I was saying when there are stages to it, and the dilemma is where is the risk, or where has the allocation of loss of bargain been placed in the event of proven negligence. But one also has to bear in mind that clause 14b is not one-sided. There is an element of exclusion clause to it. And why I say that is as follows. We have an implied obligation of readiness here, albeit one to exercise reasonable care or due diligence to have the vessel ready. And what's being said is, notwithstanding that there'll be a right of cancellation for any lateness, there will be no monetary remedy unless sellers can first get past that threshold of proven negligence. And that's how Clause 5 and Clause 14 work symbiotically. So finally, my section 6 is authorities on the NSF form, and the only one to develop today is the sole halt. And one starts, please, with the first instance decision, which is at page 680. And we have to look at first instance, partly because it shows more of the facts, partly because it has led to what we say is settled market understanding. There's a clear similarity with our facts, having squeezed in a final voyage the sellers failed to tender the vessel for delivery before the 31st of August 1979 cancelling date, and the buyers cancelled and claimed loss of bargain. And if one picks up, please, at page 684, the right-hand column towards the bottom, issue 1 is the equivalent of our case. Does the sale contract in the events that have happened give the buyers a remedy in damages? And then at the bottom of the page, there's the quotation of clause 14. And over the page, the last line is the due compensation provision, with there the words cause to the buyers by non-fulfilment of this contract. And then clause 17, which was a delivery obligation, which we say is not materially different to clause 5 of our case. And then in the middle paragraph, left-hand column, one has 3 arguments by
Which
Mr.
page?
Pollock.
Sorry. Which page?
685,
Yeah.
please. 3 arguments by Mr. Pollock, and the third is what matters. So at the bottom of that paragraph, he submits for the sellers, the clause only provides for loss caused by non-fulfilment of the contract. That means loss arising from the default and not from the loss of a bargain if the buyers are entitled to and do treat the contract as at an end. That argument is rejected at the bottom of page 685, right-hand column, also under the introductory word thirdly. So there was a prima facie entitlement, one sees at the top of page 686, to $500,000 in market damages. So compensation following cancellation under clause 14 of this prior iteration of the NSF was held to follow a breach of contract by failing to deliver by the cancelling date, and cancellation thereafter, and due compensation was held to be loss of bargain. And that was ratio because these were necessary precursors to the decision that the buyers had failed to mitigate. The Court of Appeal decision starts at page 689. The only issue on appeal was mitigation, but the Court of Appeal endorsed the judge's decision, we say, on the key point. At page 691, in the paragraph starting Mr. Sumption, the submission for buyers was that if there is cancellation, the loss will be attributable to the seller's breach of contract and not to the cancellation. And then over the page at 692, the Master of the Rolls said in the bottom half, left-hand column, buyers had an unfettered right to cancel. No question of mitigation arose at that stage. They decided to cancel, in consequence suffered a loss of $500,000. As a matter of causation, this loss, unless avoidable by some reasonable further action, was directly attributable to the seller's breach of contract. And then we rely on our detailed comparison of the Solholt and the NSF 2012 at paragraphs 36 to 42, and that's pages 52 to 55. So there are other authorities of some relevance, which we cover at paragraph 62, but we accept that they are not as clear for various reasons. So I conclude by paraphrasing Lord Justice Moore-Bick in the Gearbolt case, and that was cited for present purposes in the Court of Appeal judgment at paragraph 124 on page 106. So Lord Justice Newgy referred to a similar point as arising here, having been argued in the Gearbolt case. And Lord Justice Morbick said, whatever may have been said in other cases about other contracts, and we paraphrase that to say, whatever may have been said in other cases about other contracts, it is clear that the MOA proceeds on the footing that if buyers chose to cancel and are able to establish proven negligence, then seller's breach is to be viewed as the effective cause or an effective cause of the termination of the MOA.
Sorry, where was that? I missed this reference.
Sorry, page 106,
Court of Appeal 124.
paragraph 124, and it's a citation of paragraph 36 of Lord Justice Morbick in Gearbolt. So, unless there are any further questions from me, I pass over to Ms. Bond for the respondent's notice point.
Are you making anything of the subsequent change to include loss of bargain in the latest version of the form?
It's post-contractual, so I rely upon it with trepidation. But we do say that it leaves the NSF 2012 in the middle of a sandwich, whereby there's clear authority that the prior version was something that extended to loss of bargain. The later version clearly extends to loss of bargain. And what we don't accept is that there was any intention by the drafts people to have some different regime in that interregnum. Rather, the committee has now made clearer still what we say is already clear enough under 14B of the 2012 form.
Thank you.
Yes, Ms. Bond.
Good afternoon, my lords. I will be addressing the court on buyer's respondent's notice point, and this is found at page 194 of the hearing bundle. And this is that insofar as financings establishes any principle that the exercise of a contractual termination right following a breach of contract does not ground recovery of loss of bargain damages, any such principle does not apply to claims for non-delivery and non-acceptance under sale of goods contracts. And for ease, I refer to this as the sale of goods context. As has been explored by Mr. Lewis KC, our primary position is that the scope of any such financings principle is irrelevant because the case turns upon the proper construction of Clause 14B alone. However, to the extent the panel considers that it's necessary to ask what the recoverable damages would have been under common law under 14A in the absence of Clause 14B, then buyer's position is that this common law position is or should be different in the sale of goods context. Before turning to my...
Just to be sure where we're going, so you ask us momentarily to put Clause 14B out of our minds and just look at 14A on its own.
Indeed,
I rather rigorously put to your leader that if 14A stood on its own, you wouldn't mind anybody.
Indeed. So it's a somewhat artificial exercise because on our primary case, we're considering 14B, but on seller's case, it's necessary to consider what the common law position is, and that's why we're dealing with it in our respondent's notice. So before turning to my submissions on this point, I'll briefly take my lords to what the Court of Appeal said about this and the financings principle. This is at page 103 of the hearing bundle. So starting at paragraph 114I, the Court of Appeal set out what we are referring to as the financings principle, which is, I don't need to repeat it. If I could just ask you to read 114I to yourselves.
Yes.
And then moving ahead slightly to page 104 and paragraph 118, Lord Justice Nugie noted that both financings and the cause, as well as Phones for You and Spa Shipping, were all concerned with long-term contracts which were, I quote, prematurely brought to an end by the exercise of a right to terminate. Then, at 119, which is the critical part of the judgment, His Lordship noted that it was not obvious that the same principles necessarily applied to contracts for a single transaction, such as a sale. And then if I could ask my Lords to read the rest of that paragraph to yourselves. For the reasons I will explore now, our submission is that Lord Justice Nugie's inclination was entirely correct. Our written submissions on this point are set out at paragraphs 69 to 85 of our skeleton, which is at pages 65 to 73 of the hearing bundle. However, in the interest of time, unless my Lords have a different view, my oral submissions will be divided into two parts. First, I will address the Court on why, as a matter of authority and principle, respectively, financings does not or should not apply in the sale of goods context. And second, I will address the Court briefly on why this matters, although we have somewhat covered that at the beginning.
Ms. Bond, we're getting a bit of feedback. I don't quite know why.
It seems to have gone.
Have another go and see if you're tweaking the
Just stop me if you
microphone.
can't hear me.
Yeah.
So, dealing with the authorities first.
So what was the second point you made?
The second point is why it matters, but I've already addressed you on that, and we say our primary case is that it doesn't matter, but if sellers are right and we need to look at what the common law position would have been, we say that, well, the common law position is essentially different in the sale of goods context. So dealing with the first point, the authorities, it's significant that sellers have not identified a single authority in which financings has been applied, or even obiter dicta in which discusses financings in the sale of goods context. I will deal with each of sellers' cases in turn to make this point good. First, there is financings itself, which is found at page 325 of the bundle. By way of summary, financings concerned a 2-year hire purchase agreement which was terminated by owners for non-payment of 2 instalments of hire. It therefore dealt with a long-term rather than a one-off agreement. The agreement contained a termination provision at clause 8 and an agreed compensation clause at clause 11. And as Mr. Lewis Casey has discussed, the Court of Appeal held that clause 11, the agreed compensation provision, was unenforceable as a penalty clause, and the court also held that the failure by the hirer to pay the 2 instalments did not amount to a repudiation by him of the hire purchase agreement. As Mr. Lewis has identified, the relevant issue was therefore whether clause 8 alone gave rise to a right to loss of bargain damages, and the Court of Appeal unanimously held that it did not. In our submission, it was central to each of the 3 judges' reasoning that the owners were effectively trying to claim for future breaches. And to make this point good, I'll take you to each of the judgments in turn, although these are set out in our skeleton argument. First, there is the judgment of Lord Denning, which is at page 331 of the bundle. In the last paragraph, around 5 lines up, Lord Denning states that he can recover damages for any breach up to the date of termination, but not for any breach thereafter, for the simple reason that there is no breaches thereafter. Echoing this is the judgment of Lord Justice Upjohn, which is at page 337 of the bundle. And the passage I wish to rely on is inconveniently located in the middle of this page, but it's the sentence that starts, therefore, the only damages for which he could sue were those pointed out by clause 11 of the contract, together with any claim he might have had for some other damage for antecedent breach. Third and finally, if my lords could turn to page 344 and the last page of the law report and the last sentence, and this is the judgment of Lord Justice Diplock. His lordship concluded his reasoning by saying that absent a repudiation, although a party may be entitled under express power to determine the contract, that party is not entitled to damages for non-performance of the contract during the period for which it would have continued to run but for such a determination. What follows in our submission is this. Financing stands only for the proposition that the exercise of a contractual termination right does not, of itself, give rise to liability for future breaches of contract. However, in our submission, financings does not stand for the broader proposition that the exercise of a contractual right based on a prior breach of an obligation would be deemed the sole effective cause of the loss of the bargain arising from the non-performance of that obligation. The second case relied upon by sellers is Phones for You, which is found at page 518 of the bundle.
So is this a submission that the causation argument is not the best interpretation of the financings and Baldock line?
It's a submission that the better explanation of the financings principle is the kind of future breaches explanation, that the reason why there was no recovery of loss of bargain damages in that case was because it would allow the party to recover for future breaches. And as I will come onto when I deal with principle, that explanation just does not apply in the sale of goods context.
In fact, the contract's a rather odd construct because it did provide for damages, but the provision, or for compensation, but the provision was void as a penalty. Yes. Yes.
It was a...
It was the sort of half chopped up version of the agreement that everybody had to construe.
Yes, but it was almost like you were just considering 14A, for example.
Yes, certainly.
The second case is Phones for You, which is at page 518 of the bundle.
518?
518, yeah.
Thank you.
And again, in the interest of time, I'm summarising, but Phones for You had entered into a long-term contract with EE under which EE would pay Phones for You for selling mobile contracts to new customers. One of these contracts, referred to in the judgment as the trading agreement, contained a cancellation clause allowing one party to terminate in the event that the other party took any steps to initiate any form of insolvency proceedings. In September 2014, following Phones for You appointment of administrators and cessation of trading, EE sent a termination letter to Phones for You in accordance with that termination provision. And as part of the proceedings, EE had counterclaimed against Phones for You for loss of bargain damages resulting from the termination, and Phones for You applied for summary judgment to dismiss that counterclaim. Mr. Justice Andrew Baker held that EE had a reasonable prospect of alleging a separate breach of the trading agreement, which on the facts was a breach of something called the key obligation. The judge also held that EE had a reasonable prospect of establishing repudiatory breach on the part of Phones for You at the time of the termination letter. However, the terms of the termination letter defeated any claim they may have for loss of bargain damages. There are two significant points which emerge from Phones for You, which are also 2 points of distinction with the present case. Again, the trading agreement was a long-term contract, and the issues did not arise in the sale of goods context. The second is that the court was considering the recoverability of loss of bargain damages in the context of a bare cancellation right, which did not depend upon the proof of breach, as Mr. Lewis has already identified. The third authority is the cause, and I don't propose to...
But the only point, I mean, you're asking us to look at this as if this contract only contained 14A. So the only point of distinction between this case and Phones for You is that this is a one-off sale of goods contract, whereas Fairness for You is a long-term relationship.
Yes,
Yeah.
yes,
Yeah.
yes. And Mr. Lewis has very helpfully pointed out that Fairness for You did not concern a termination for breach situation, but a non-breach. So it's a bare cancellation right, which did not depend.
Yeah, it didn't need a breach.
As is, I think, all of the cases that I will take you to. The third authority is the cause, which is page 295 of the bundle. And again, in broad summary, the issue here was whether owners under a time charter could recover from charterers under an indemnity provision the cost of services provided between owners' withdrawal of a vessel and the completion of cargo discharge. The Supreme Court held that the indemnity provision was applicable where the order of charterers had been an effective cause of the owner having to bear a cost which he had not contractually agreed to bear. Again, and at risk of repetition, is the simple point that this concerned a charter party, i.e. a long-term agreement, not a sale of goods contract, such that to the extent sellers rely on any of the remarks of Lord Sumption, that has to be borne in mind. The second point is that charterers' argument, as with Fairness for You, was that the sole cause of the loss claimed was owner's decision to withdraw. And the Supreme Court rejected this. And again, the remarks of Lord Sumption, which are relied upon in Sellers' Skeleton at paragraph 7, must be read in this context, i.e. a bare cancellation right. The third point is in relation to Lord Sumption's findings at paragraphs 13 to 15, which are at page 305 to 306. And in the interest of time, I won't read these out, but in those paragraphs, Lord Sumption held that owners could nevertheless recover under the indemnity provision because their loss was a consequence of charterer's prior order to load the cargo. And what we say is that depending on the proper construction of an express provision, losses suffered after contractual cancellation may be recoverable based on the prior conduct of a defendant. And our further submission from this is that this stands against any bright line rule of causation which sellers rely upon. And the final three authorities, which I will somewhat roll up before moving to the arguments of principle.
Sorry, can you just give me that last point again? Because I thought you were saying in the better interpretation of financings is that this is not a causation explanation, it's rather that it's a future breach. What are you then saying about the COS decision?
What we're making two separate points about the COS decision. The first is that it was, a bare cancellation right, and that's the first point. The second point, which is a somewhat different point, is that what we say is Lord Sumption's finding is inconsistent with any bright line rule of causation which sellers rely upon.
Isn't it also inconsistent with the future breach idea? Or have I missed the point?
Well, what Lord Sumption held is that owners could recover because their loss was a consequence of the charterer's prior order to load the cargo. It wasn't in respect of the future breach, it was the prior order to load the cargo. So it's backwards looking rather than forwards looking. So what we say is there's no inconsistency with financings.
Okay, thank you.
So rolling up the last three authorities which sellers rely upon, the first is spar shipping in the commercial court, and I won't take you to that, but again, I make the point again that this was a long-term charter party, and such that the remarks of Mr. Justice Popperwell must be read in this context. And it's clear from those paragraphs, paragraph 96 to 100, which, just for your reference, is page 713 to 714 of the bundle. Mr. Justice Popperwell's reasoning was heavily informed by financings, which I've already addressed, my lords, on. And the final two authorities are the Australian authorities, which is AMEV and the Cheval case. I do not propose to spend much time on this, save to make the point that AMEV concerned long-term leases, and the majority simply applied financings, and Cheval concerned a long-term rental agreement. So what we...
Is there any discussion of financings in Benjamin, for example?
We have not located any discussion of financings in Benjamin that is relevant to this part of the case. I can't say yes or no to whether there's anything in Benjamin
no relevant discussion
about financings.
Well, you've told us why this great litany of cases doesn't help, essentially because they're all about long-term relationships. This is a one-off contract of sale. But in your remaining 7 minutes, why does the fact that this is a sort of sale of goods case make all the difference so as to produce a different outcome?
That's what I'm about to tell you.
Oh, good.
But it was necessary to address each of the cases to show that sellers have not produced a case in which it's been applied in the sale of goods context, or even the one-off context. In our submission, there are 3 related reasons why any principle from financings does not or should not apply in the sale of goods context. The first draws from the reasoning in financings itself, is that the true ratio of that case in our submission is that it's not possible to recover loss of bargain damages following the exercise of a cancellation clause, because that would allow recovery for future breaches which may or may not have occurred. In the single transaction situation, the relevant breach is not only historic, but it is that which entitled the buyers to cancel, such that the future breaches rationale just doesn't apply. The single purpose of the contract is the sale of a particular good by a particular deadline which sellers have already breached. So that's the first point of principle, which is the future breaches point. And the second argument of principle, which Lord Burrows identified in our discussion earlier, is that under general principles of causation, the chain of causation is only broken by a claimant's conduct that obliterates the defendant's wrongdoing pursuant to a fact-sensitive, practical inquiry. And it's well-established authority for this proposition is from the Borealis case, which I won't take you to, but applying that principle in this case, where the whole purpose of the transaction is that sellers provide a good to buyers in return for the price and provide that good within a stipulated delivery window, the prior breach in our submission remains at least an effective cause of the loss. Buyer's cancellation in reliance upon the prior wrongdoing cannot be said to obliterate that prior wrongdoing. As Lord Justice Nugi says in his judgment, this is not a case of premature termination. And as my learned friend highlighted earlier in his discussion of the Spark Appellant, it's not a situation where you're in month 3 of a 2-year time charter and then it's brought to an end at a premature stage. It's the sale of goods context where it's a kind of one and done situation. The whole purpose of the agreement is to provide a good within a stipulated window. And if you don't do that, then it's difficult to see how the whole purpose of the transaction isn't just called off. Before moving on to final argument of principle, I will deal briefly with the point raised by my learned friends in their skeleton that our argument is inconsistent with the Bungi case.
With which case?
The Bungi case, Bungi and Nadira case.
Oh, yeah.
That there is no relevant distinction between one-off sale contracts and long-term contracts in relation to the relevance of post-breach events to the assessment of loss. And Mr. Lewis Casey has already addressed you on this case. But what we say that the difference is that whether subsequent contingent events should be taken into account in assessing damages is an entirely different question to the present case. In the Golden Victory Bungie context, it's the overriding compensation principle which makes it unsurprising that a consistent approach should be adopted. And indeed, we say that's clear from the reasoning of Lord Sumption in Bungie itself at page 246 of the bundle, paragraph 22, and we're about 7 lines up from the bottom of paragraph 22, where Lord Sumption refers to the compensatory principle. However, what we say is, in our context, application of the financing principle to the sale context is in fact very difficult to reconcile with the compensatory principle, because where the buyers cancel, they're always going to lose the bargain, such that it follows as a matter of course that in order to be properly compensated for that, they recover damages for loss of that bargain. So that's why we say that the fact that they rejected a distinction in the Bungie case does not mean that you should reject the distinction in this context.
You've got one final reason, I thought. You said there were going to be 3 reasons, and that wasn't one of them.
I do have one final reason. I won't take you to each of the cases in that reason, but it's that
just give us the
it's
headline.
undesirable to extend the financing principle, because that's what you're invited to do, is extend it to the sale of goods context, because there is no authority applying it in that context, in light of the criticism of the financing principle as it stands. And this is all set out at paragraph 84 of our written case at pages 71 to 72.
These are criticisms made arguably, but, well, some academic criticism.
These are criticisms made firstly in Canada, where they don't apply financings, and there's 2 further articles. And we'd also invite my lords to read Carter and Chitty in relation to this, which, as set out by Lord Justice Nugee, is not completely clear that financing applies across the board. So unless my lords have any further questions, that concludes.
No, thank you very much indeed, Ms. Bond. Mr. Russell.
I'll deal with the respondent notice.
You can take it, Mr. Russell, if you're under pressure, that the clock is about 2 minutes fast.
I'm not convinced that 2 minutes is going to make all the difference. It rarely does. I'll lose 2 minutes getting my stand set up anyway. In relation to the respondent's notice point and whether this is limited to long-term contracts or not, we say that it is a principle of causation when one reads the authorities, and there is simply no reason why it should be limited to long-term contracts. The essence of it is that it is not the breach that prevents future performance. It is the election to exercise the contractual right to terminate which causes the loss of future performance or the loss of the bargain. I do not believe that there is an express reference to financing in Benjamin, but there is in Chitty. It's in the bundle at page 953, and it is in an entirely general section in relation to the provision for discharge in the contract itself, and the paragraph which we have relied on, which is 26-063, is itself in entirely general terms.
Sorry, page?
Page 953. And contains no suggestion that the principle is limited to certain kinds of contract. And we say, if one thinks about it, the circumstances of this case are, as a matter of principle, the same as where a long-term contract is terminated. Because this is a case where the breach was not being ready by the delivery date, not a non-delivery case. Sellers intended to deliver and were expressing an intention to do so. And what prevented the fulfillment of the contract was the election to terminate. And so, as a matter of principle, there's no difference between that case and a long-term contract. The future performance that is lost in a long-term contract may extend further into the future, depending when in the life of the contract the election to terminate is made. But one is still talking in both contexts about the loss of the future performance in a sale of goods case, the delivery of the goods. In the case of a long-term contract, whatever it might be. And the right analysis is that, as a matter of law, that right to future performance, the bargain, is lost by reason of the election to terminate. Lord, if I could take you then to the decision in the Solholt.
Just before doing so, we have 5 categories of expenses. They will be fully incurred when the person exercises the option, the buyer exercises the option to cancel. Are those losses recoverable?
They're recoverable under the rubric of all expenses.
So the financing principle doesn't apply. It's that they're legally caused by what?
In my submission, the financing principle does apply, but the words of the clause
Are sufficiently clear.
Are sufficiently clear, yes.
So the words all.
All, exactly.
All. Right.
So all expenses, we say, there is a certain impressionistic aspect to this.
Okay.
That when you read the clause and it says compensation for all expenses,
Yes.
that conveys to the reasonable reader that you are going to get your wasted expenses, because the wasted expenses are part of all expenses.
Even though you've caused it yourself.
Yes.
But by exercising your right to cancel.
I accept that. There is. I accept that there is a what our friend says is a tension in our argument, in that we treat on our construction of the clause expenses differently from compensation.
Yeah.
We do so unashamedly because the wording all expenses is sufficiently wide to capture the wasted expenditure, even though it has been caused by...
But you also treat losses differently as well, because if there is a non-accepted repudiatory breach, that falls within the term losses.
Well, that's the question. So,
I thought you'd accepted that.
Well, both the wasted expenses and the loss of bargain would be caught by the financing principle. The difference is that the wording in this case in relation to expenses is sufficiently clear to disapply the financing principle and allow recovery of the wasted expenses. It's not sufficiently clear to allow the recovery for loss of bargain.
And that's all in the all.
Sorry?
That's all encompassed within the all.
It's encompassed by the all, but also simply as a matter of reading the clause and asking oneself what it would convey to the reasonable reader.
Yeah, sure.
If you say you can recover compensation for all your expenses, reading that part of the clause as a whole, it conveys that you get your wasted expenses in a way in which we say very definitely compensation does not include loss of bargain compensation, where the established principle applies that the cause of that loss is the election to terminate. And perhaps if I can deal with that, I mean, the essence, in relation to loss of bargain damage, and remember, of course, it's loss of bargain damages that we're talking about here. The essence of the decision in the Court of Appeal and my learned friend's submissions, and this is a point I discussed earlier with Lord Stevens and Lord Burrows, is it enough for loss of bargain damages or the loss of the bargain to fall within the rubric due compensation for their loss if only factual causation is established, if it is only the case that, as a fact, the buyers have suffered the loss. And it's perhaps not even right to refer to it as factual causation. It's certainly the way in which it was being put to me earlier was simply, is it enough that the buyers have suffered the loss? Now, in my submission, that cannot suffice. Because if that were enough, it would involve jettisoning a whole host of common law principles such as causation, remoteness, and mitigation. I mean, one can imagine all sorts of situations where, as a matter of fact, the buyers have suffered a loss, but the loss would not be recoverable. So, I mean, if one takes as an example a case where the buyers cancel, sellers have been guilty of negligence but not repudiatory breach, the market hasn't moved, say, the market is the same as the contract price, but buyers have entered into a long-term charter party at a very favourable rate. They're unable to obtain a replacement vessel in time, and their charterers cancel. Now, as a matter of fact, the buyers will have suffered the loss of profits that they would have earned under the time charter party, but they wouldn't be able to recover, either because it would be held that the time charter party was res inter alios acta or was too remote. I mean, similarly, the same scenario, but the buyers in this case, because they're desperate to maintain their long-term time charter party, buy a replacement vessel very quickly, well above the contract and market price. They've suffered a loss because they've had to pay more than they would have done under the contract. But as a matter of law, they wouldn't be able to recover that loss.
Well, a sole hold is an example.
Yes, exactly. So the sole hold was an example I was going to give. No doubt under the sole hold that the buyer suffered a loss, but they were not able to recover because principles of mitigation apply. Now, in the Court of Appeal and in the judgment of Mrs. Justice Dias, it was expressly stated at paragraphs 71 and 72 in the Court of Appeal decisions. This is paragraph 92. I beg your pardon, page 92 of the bundle. So page 92, paragraph 71 and 72. There's reference to due compensation. I consider it clear that this does not mean compensation that has already accrued due. It means proper or appropriate compensation. This was what the judge said, as follows. I agree with buyers that due compensation means compensation which is appropriate using the common law principles of causation, remoteness, and mitigation. All three sets of principles, causation, remoteness, and mitigation. I do not accept seller's case that the phrase has the effect of limiting recovery to accrued damages, which would otherwise be recoverable in any event. That, it seemed to me, would put a very strained construction to the words. And then Lord Justice Nugee said, Orion takes issue with this in ground 2 of its respondent's notice, but I think the judge was entirely right. So the judge, the Court of Appeal, endorses the the judge's view that due compensation means compensation which is appropriate using the common law principles of causation, remoteness, and mitigation. Another friend, in an answer, I think, to a question from Lord Burrows, said that he accepted that the principles of remoteness and mitigation would still apply to due compensation under the clause. But once you accept that, you have already departed from the line of argument that it is sufficient for recovery of compensation under 14b that the buyers have in fact suffered the loss. So that can't be the answer if you accept that principles of remoteness and mitigation apply. The question then arises, well, why is it that we are jettisoning one principle of causation, remoteness, and mitigation, but no others? There is simply no justification in our submission for a construction of the clause that says due compensation means compensation which is appropriate using the common law principles of causation, remoteness, and mitigation, except for the principle of causation that in the absence of a repudiatory breach, the exercise of a right to cancel is not treated as being the cause of the loss of the bargain. There is no justification, and none is offered, no justification as to why that single principle of common law assessment of damages is derogated from or departed from or simply jettisoned. The fact that there is no rationale even offered to explain why we jettison this one principle is, we say, fatal to the case. I mean, putting it another way, the Court of Appeal have said that they are doing one thing, assessing compensation using the common law principles of causation, remoteness, and mitigation, but self-evidently they have not done that. My Lord, I wonder if I might take you very briefly to the decision in the Solholt and wrap up with an analysis of that, what we say about market understanding. I'll do it as swiftly as I can. So the Solholt at first instance, and we can go straight to page 685. Bottom right hand of the page, the paragraph starting thirdly.
Yeah.
The point here is that this is the 1966 iteration of the form. And what it provides for is compensation for the non-fulfillment of the contract, loss caused to the buyers by non-fulfillment of this contract. So the test of causation embedded in that version of the clause is not the common law test of loss caused by the breach. It is a contractual analysis provision, loss caused to the buyers by non-fulfillment of this contract. And given that wording, it is easy to see, or easier to see, why the courts reached the decision that they did, because the compensation that is being provided for is the compensation for the buyers not getting the vessel. It's not compensation for breach, it's compensation for non-fulfillment of the contract. Fulfillment of the contract is that they get the boat. Non-fulfillment is they don't get the boat, and they get their loss of bargain. unless you indulge me further, those are my submissions.
Thank you very much indeed. The court is most grateful to all counsel who've addressed us and to the wider teams, including counsel who've not addressed us, for all the careful preparation that went into the written and oral submissions, which we've considered. We will go away and give further consideration to both the oral and the written submissions before letting you have our judgment. Thank you.